Hi, Ms. Gonzalez. Hi, Ms. Gonzalez.
I'm sorry, were you speaking with me?
Yes.
Okay,
Can I give you a call real quick?
sure. Let me turn this off. You need a phone number?
Yes.
602-230-8448.
Hey Patrick.
Hey, good morning. How's it going?
Good. Everything gets set up okay?
Yeah, I think everything's on track. We still only have, I don't know if you can see this, but there's just two witnesses in the waiting room right now. So I
Okay.
think,
Um, yeah, I can't see any of that. Anna just sent me the link to just like join as a participant. So, if you want to make me, uh, I mean, it's your hearing, but if you want to make me a co-host, then it can be helpful because if somebody joins after you start talking, I can let them in.
sure.
You
Yeah,
know,
just
so if you wanted to do that, I'm happy to handle that part of it.
great.
Um, okay, cool. Everything
We're
seems
live. Also, Jocelyn, by the way.
okay, cool. All right, good.
Well, I'll be back in 1 minute, and then hopefully some of the parties will be on and we can get started. Thanks. Okay, good morning, Ms. Gonsalves. Ms. Barrett, I'm going to start letting the attorneys in and discussing just preliminary matters before we get on the record formally.
Very good.
Thank you. And right now, I'm still only seeing the Stelzner law firm. I don't know if we have any other attorneys in the waiting room.
I'm showing 7 people, 8 people. Do you want me just to admit them? I don't know why I'm seeing them and you're not.
Well, I see witnesses.
Oh, witnesses. Oh,
Yeah,
okay, never
so
mind.
I wanted to just do some discussion with the attorneys or interveners first. Mr. Herman, are you there? Are you with us?
Good morning, Xander. Yes, I'm here.
Hi, good morning. Good to see you.
Is my audio okay?
Your audio sounds very good. Yes.
Thank you.
Just to let you know, we're live on YouTube, currently being recorded. We're not on the record yet. I've been hoping to gather some of the attorneys before we go formally on the record just to discuss any preliminary matters. But it looks like we don't have all the attorneys here yet. So maybe we'll just hang tight for a minute and wait for them to join our call.
How's the baby, Keith?
Uh, different baby every day.
Good.
Are you guys in the office now, or did they solve the flooding problem?
Yes. I think in the interim, we're still looking for a forever home, you could say.
That's been a years long search so far.
Right, right.
I thought the legislature allocated some funds for you to take over that building off Cordoba, but it's not much bigger than I think the space y'all have there.
No. Miss Lynch, are you with us?
I am. My headphones just needed to connect.
No worries. Good morning. We're live on YouTube, being recorded. We're not currently on the record. And I just was waiting for the attorneys to arrive and just discuss any preliminary things off the record if we needed to, and then start the proceeding formally. I have to tell you that Mr. Herman and yourself as intervener are, I think, the only non-witness attendees that we're letting from the waiting room, or that were in the waiting room. So I just maybe will hang out for a few more minutes and see who joins.
Are you waiting on the company to join, or?
We have a El Paso Electric witness in the waiting room,
I
but
think,
go ahead.
Examiner Schaefer, I think STFCR Zobra might be Shaner there. That might actually be the room in which their lawyers broadcast from. So if you want to try admitting that,
Sure.
I think Ms. Olson might be there.
Okay.
Okay.
And do we have any sign of Commissioner Fishman?
Not yet.
And
Hi,
I don't have, I'm sorry,
Go
go
ahead.
ahead.
I was just going to ask for STFCR Zobra to let us know who they are.
Good morning, hearing examiner Schaefer. This is Carrie Olson on behalf of El Paso Electric Company, and I have Deputy General Counsel Nancy Burns here in the room with me.
Okay, great. Thank you. Yes. Well, we are live and on YouTube. We're not formally on the record yet. Ms. Olson, thank you for being with us. And I wanted to just get everybody together briefly and formally to discuss if we have any preliminary matters that have arisen or that are on your minds that we might want to discuss before proceeding to our formal evidentiary hearing.
Mr. Hearing Examiner, if I may, just my situation with Mr. Sanchez.
Yes, that is something I was going to raise as well, but I thought that we could just check with El Paso Electric first as the moving party and see if they have any thoughts about that or anything else in particular.
Mr. Hearing Examiner, we do have one minor witness conflict. And so we would ask permission, if it's okay with the parties, to present Mr. Wayne Oliver out of order. I don't think we actually designated order of witness, but our proposal would be to present Mr. James Schiestel first and then present Wayne Oliver second, and then proceed with Emmanuel Villalobos and Renee Gonzalez.
Do the parties have any objection to that order of witness for the applicant? Okay. We'll get that on the record here formally in a second. So with respect to Mr. Bagatko's question, I think all of you know that staff witness Sanchez has a conflict and would like to proceed with his testimony here at the beginning. Are there any objections of the parties to that? It's a bit unusual, I know, but in the interest of accommodating people's needs, I thought that we should discuss it and then make a decision.
Mr. Examiner, the county would be willing to waive in Mr. Sanchez's testimony. We don't have any cross. In fact, we have just very limited cross for Mr. Schiestel. So on another note, I'd ask for my absence to be excused after Mr. Schiestel, unless something changes it here,
Sure.
or he deferred my
Okay.
questions.
Sure, I'll take note of that. Thank you, Mr. Herman. El Paso Electric, any objection to going ahead with Mr. Sanchez first?
No, Mr. Hearing Examiner, as Mr. Bagatko pointed out in the motion, I think staff in El Paso Electric have resolved all issues and is the only two parties offering evidence. I don't have any cross-examination planned.
Okay, thank you. Ms. Lynch?
I don't have any opposition to that order of presentation.
Okay, great. Okay, well, I think we were maybe expecting Mr. Fishman to participate today. Maybe he'll join sometime later, but I don't see him at the moment. So I think unless there's anything else, go ahead, Mr. Bagatko.
Yes, Mr. Hearing Examiner, I'm just going to report to you and Madam Hearing Examiner that I am in the building and my broadband is not working very well. And I'm looking at the option of going to my Wi-Fi hotspot, and it keeps my Verizon service keeps going from full bars down to just one bar intermittently. I don't know what's going on, so I'm just going to do my best to make sure this works. If you have any issues, please let me know.
Thank you. I noticed a slow connection too. I'll tell you, Mr. Bagatko, you're coming in loud and clear as if you were right next to me. So be assured that your participation is in vivid living color here. Okay, well,
Sorry.
yes, Ms. Olson, go ahead. Yes.
I apologize. I'm just realizing, so the way that we typically conduct our hearings, the EPE witnesses are actually in El Paso, and then I'm appearing from our office in Santa Fe, and I believe that El Paso Electric folks are waiting in the waiting room to be admitted. Just wanted to alert you to that in case you were wondering who they were.
Yeah, actually, thank you for raising that. So we'll admit the witnesses, as you call them, as the parties call them. We have here in the waiting room just a moniker, a label. It says EP witness. So I suppose that is will rotate between the witnesses. Is that correct, Ms. Olson? That
So
all
it's,
witnesses will be using that EP witness handle?
yeah, so that is literally the room at El
Right.
Paso Electric where the witnesses are. And then I think there potentially is separately someone identified as EPE, like technology support or something, who is like the facilitator. So if they could be allowed into the hearing, that would be helpful.
Okay, sure. You mean when it's time to call them, I suppose?
Or for the whole hearing, because they're kind of monitoring the logistics on the El Paso office side.
Okay, so maybe we'll admit them after Mr. Sanchez presents, or do we even need to call him as a witness? Is Mr. Bagacco, we don't, is there a staff attorney here from PRC?
Just me.
Okay. All right, so let's just go ahead and call Mr. Sanchez and get his testimony admitted, and then the parties can proceed with any cross. So I did also want to mention, just again off the record, we can do this here formally in a second, but the order of cross has been organized according to intervention date. So that would be Doña County would have first opportunity across. Mr. Fishman would have a second opportunity. CCAE would have third. And also, I'll just say we're expecting a member of the commission staff from the policy division to join, Agatha Malik, who may want to ask questions after the interveners have proceeded with cross. And then at that point, if hearing examiner has any questions, we can go in that order. Is there any objection or a strong response to that order? No? Okay, well, good morning.
Electric in that order.
What's that, Mr. Herman?
Where is El Paso Electric in that order for staff witnesses?
For staff witnesses, EP would go first on a cross of staff witness, yes. Thank you. Okay, well, good morning again, everybody. Let's go on the record here. And I will note that the time and place is 9:11 a.m. We are physically in Santa Fe and also online and being broadcast on YouTube. My name is Patrick Schaefer. I'm the hearing examiner assigned to the case. The co-hearing examiner that the commission appointed to this case, Christopher Ryan, had an unexpected conflict and will not be joining us today, but he will certainly participate and has participated in the review of the evidence and will be involved here in the drafting of the recommended decision. I also would note that Jocelyn Barrett is here from the Hearing Examiners Division to provide any support or other eventualities that need to be addressed. We are here for a hearing in case number 250038 UT. That specifically is the application for approval of El Paso Electric Company's Renewable Energy Act Plan for 2026, and the 9th revised rate number 38, the RPS cost rider. I'll also note for the record that on May 16th, an order extending the application review period to 180 days and suspending the advice notice 309 appointed myself, Patrick Schaefer, and Christopher Ryan as hearing examiners. Also for the record, I will note that a notice of this hearing was provided by El Paso Electric and confirmed in their declaration filed in this docket on June 17th. I now take a moment to recognize our court reporter, Ms. Gonzalez, who's joining us again, maybe a familiar face to several of you. I wanted just to mention that she will be swearing in, obviously, as all of us know, the witnesses before they provide their testimony, and that any questions about the transcript should be directed to the court reporter. I'll also say that we will try to organize breaks around an hour and 15 minutes or so, depending on flow of testimony, discussion, or anything else that is going on in the hearing. With that, I would like to invite the parties to state their appearances for the record, starting with El Paso Electric.
Good morning, Carrie Olson from Spencer Fain on behalf of El Paso Electric, and with me is Deputy General Counsel for El Paso Electric Company, Nancy Burns.
Nancy Burns, nice to see you both. Thank you. Doñana County.
Good morning, Mr. Examiner. Keith Herman on behalf of Doña Ana County.
Thank you. The Commission for Clean Affordable Energy.
Good morning, Hearing Examiner Kara Lynch on behalf of CCAE.
Thank you. And I think that's all the parties we have here to state their appearance at the moment. Mr. Nybert, Commissioner Nybert has joined. I will admit him and get him here to participate on the record.
Mr. Hearing Examiner, do you want me to state my appearance?
Yes, thank you, Mr. Bagacco.
Hi, everybody. Good morning, Mr. Hearing Examiner, Madam Hearing Examiner, everybody. This is John Bagacco with the NMPRC Legal Division representing the Utility Division staff. Thank you.
Thank you. Good morning, Commissioner Nybert. I see that you've joined us, and we are on the record and stating our appearances for the record.
I'm just going to listen in briefly. We have a workshop in a moment. I just wanted to observe. Thank you.
Thank you, Commissioner Nybert. Okay, well, with that, I think all the parties have stated their appearances, and I believe we are ready to call the first witness here. And Mr. Bagacco, well, before that, just let me state again for the record that Mr. Herman's appearance will be excused at the time that he needs to remove himself from the hearing, and there was no objection. Mr. Bagacco, would you like to call your first witness?
Yes, please, and thank you to everyone for allowing Mr. Sanchez to go first. Mr. Sanchez, if you're ready, please come on down.
Yes, I just admitted him. He should be joining here momentarily. There he is.
Raise your
Good
right
morning,
hand.
everyone.
Raise your right hand and I'll swear you in. Excuse me. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
May I proceed, Mr. Hearing Examiner?
Yes, please proceed, Mr. Bagacco.
Thank you. Good morning, Mr. Sanchez. How are you?
Good morning. I'm doing great, thank you. How are you?
I'm all right. I hope I'm coming through loud and clear because my broadband indicator keeps going up and down like a yo-yo. So if you can't hear me or anything seems to start getting messed up, please let me know. We are here to move your prepared direct testimony into evidence in this case. And I trust and hope that you have in front of you what's been marked as Staff Exhibit 1, Sanchez Direct. Do you have that, Mr. Sanchez?
I do.
You take a moment and just go through it and make sure that that is a complete and accurate representation of what you caused to be filed in this case on June 20th, 2025.
Yes.
And other
Yes,
than
yes.
the correction that we'll be discussing in a moment, you have no changes to make to your testimony. Is that a fair presumption on my part?
Yes, that is correct.
All right, well, now let's go to the minor correction that you did make, Mr. Sanchez, and that would be found on page 6 of your direct testimony.
Yes, so on page 6 of my direct testimony, the number $43,956,901 is incorrect. The correct number is $43,402,181.
Thank you for that, Mr. Sanchez. Now, with that correction articulated into the record and reflected in red line on page 6 of your direct testimony, my next question for you would be whether or not now at this point, if you were asked the same questions as we see posed in that direct testimony today here at this public hearing, would your answers to those questions still be the same, or would you have any cause to change them now?
Yes, my answers would still be the same.
Well, thank you for that, Mr. Sanchez. And with that, Mr. Hearing Examiner, I would move for admission into the evidentiary record, Staff Exhibit 1, Mr. Sanchez's direct testimony that was filed in this case, please.
Thank you, Mr. Begacco. Are there any objections to the admission of staff witness Christopher Sanchez testimony into the record?
No objection.
It's admitted.
Thank you. And with that, I would tender Mr. Sanchez for any examination by hearing examiners or cross-examination by interested parties.
Thank you, Mr. Begacco. El Paso Electric, do you have any cross-examination for the witness?
No cross-examination.
Thank you. Mr. Herman?
No cross. Thank you, Mr. Examiner.
Thank you, Mr. Herman. Ms. Lynch, do you have any cross-examination for this witness?
Yes, I have limited cross.
Please proceed.
Okay. Hello, Mr. Sanchez. I believe this is the first time we've met in a setting like this.
Hello.
It's good to see you. Could you please turn to pages 7 and 8 of your direct testimony? The section that focuses on calculation of the RCT.
Yes, I am there.
Okay. And there, on pages 7 and 8, you discuss the use of the consumer price index as the index used to calculate inflation, correct?
That is correct.
Is the CPI the only mechanism to be used for calculation of inflation?
For my testimony, my responsibility was to ensure that the calculation was correct and accurate. And as far as if that is the only calculation, the calculation is part of the one of the requirements for Rule 17.9.572 subsection 12A, and it states that that the consumer price index is the parameter used in that calculation. So any other calculation I did not use.
So, in other words, the CPI or the consumer price index is one of various mechanisms that could be used?
It's one of the requirements in the role to use that one specifically.
Okay, so in your expertise, the CPI must be used.
Correct.
Okay. Do you, I'm sorry, I don't know your credentials as an economist, but in your estimation, is the CPI the best, consumer index for applying inflation as it relates to the utility context?
Yes. So this data is pulled directly from the U.S. Bureau of Labor Statistics website.
Do you know what is used in those calculations of inflation?
I know, well, per my testimony on page 8, starting on line 1, I describe the actual steps that are involved in the calculation itself. Is your question, though, referring to the calculations that are from the Bureau of Labor Statistics, or the actual calculations that I verified in my testimony?
I'm more interested in the possibility that the CPI, while it's used and is offered up as an option, it doesn't necessarily incorporate calculations that apply specifically to costs to energy related costs. The costs that a utility would acquire related to building infrastructure for the use of and distribution of energy.
Mr. Hearing Examiner, I'm going to object to these questions as well outside the scope of this proceeding. I think, as Mr. Sanchez testified, we're confined by the commission's rule and the requirements under the rule for calculating RCT, and unpackaging the reasoning for that rule would be better placed in a rulemaking to change what the commission's requirements are, but that's outside the scope of this proceeding.
Mr. Hearing Examiner, I was going to object too, but it's more of in the spirit of, if CCAE wants to discuss this, I would trust and hope that there would be some sort of proffer of a foundation so that Mr. Sanchez can at least be familiar with the intricacies and the specifics of what seems to be driving Ms. Lynch's line of questioning. Otherwise, I would object because it seems to be outside of the scope. And the Consumer Price Index is established by 572.12a as the analytical mode for the RCT.
Yes, I would agree. I think we should limit the scope of the questions to the testimony that Mr. Sanchez has provided in his written submission.
I appreciate, I don't know, the confinements required here and the restatement of the rules that apply. And I also, value and validate Mr. Sanchez's analysis of the methodology used. I'm just curious whether, so anyway, I'll leave it at that.
Do you have further questions, Ms. Lynch?
Those are the extent of the questions I have for Mr. Sanchez.
Okay, is there any other party that wishes to cross-examine Mr. Sanchez at this time? No? Okay, Mr. Sanchez, thank you for your testimony. You may be excused.
Thank you.
Hearing Examiner, may I interject just one moment with the understanding that you are excused, Mr. Sanchez, so fly away, enjoy your life. I would just say this to Ms. Lynch. Ms. Lynch, if there is something that you would like to discuss, or if you have some insight on the workings of the Consumer Price Index or anything else that you would think it be apropos prospectively, and you'd want to share it with staff, I would be open to that. I just wanted to let you know that, and I appreciate you. Thank you.
I appreciate it. Thank you.
Thank you. Just before okay, so thank you for your participation, Mr. Sanchez. Now we would like to proceed with the applicant and the applicant's witness. Ms. Olson, I'm going to admit both EPE witness and EPE IT support. Is that correct?
That's correct.
Thank you.
And I'll just note too, sorry to add to the confusion, but since Mr. Oliver is an outside consultant, he's actually testifying from the East Coast, so he'll have to be admitted separately.
Yes, I see that. He's here under Wayne. So I thought that that was Mr. Oliver. Yes, thank you. And Ms. Olson, your first witness is?
Mr. James Schiestel. And I think it looks like the EP witness needs to turn on their camera.
Right, and their audio, yes. Mr. Schiestel, are you there? Can you hear us?
I am. I have my camera on. Can you hear me?
Yes, we can hear you. It's still a blank screen, but we at least have the audio sorted out, it seems.
Yeah, let me see if I can. I've turned the camera on, but it's not showing on this screen.
Mr. Schiestel, just because this has happened to me before, are you sure the cover is off the camera?
Yeah, I was going to say.
Again, I only say that because of personal experience.
There you are.
No, that's it.
Hi, Mr. Schiestel. Thank you for joining us. There might be a delay in the audio now. Can you hear me?
Yeah.
Okay, perfect. Ms. Gonçalves, would you swear the witness in?
Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Ms. Olson?
Thank you. Good morning, Mr. Schiestel. Can you please state and spell your name for the record?
James Schiestel. Last name is spelled Schichtl.
And Mr. Schiestel, what is your current profession?
I am El Paso Electric's Vice President of Customer and Regulatory Solutions.
Do you have before you what's previously been marked as EPE Exhibit number 1?
Yes, I do.
Do you recognize that document as your pre-filed direct testimony?
Yes.
Was that direct testimony drafted by you or under your direct supervision?
It was.
Do you have any corrections to your direct testimony?
I do not.
Is the direct testimony that you prepared true and accurate to the best of your knowledge and belief?
Yes.
And if you were asked those same questions today under oath, would you give the same answers?
Yes.
Mr. Hearing Examiner, El Paso Electric offers EPE Exhibit number 1.
Thank you. Are there any objections to admit Mr. Schiestel's direct testimony? Hearing no objections, the testimony is admitted into the record.
And Mr. Schiestel, do you also have before you what's been marked as EPE Exhibit number 2?
Yes.
And do you recognize that as your rebuttal testimony in this case?
Yes.
Was that rebuttal testimony also drafted by you or under your direct supervision?
Yes, it was.
And do you have any corrections to that testimony?
I do not.
If you were asked the same questions under oath today, would your answers be the same?
Yes.
And is that testimony true and accurate to the best of your knowledge and belief?
Yes, it is.
Mr. Hearing Examiner, we would also offer EPE Exhibit number 2.
Thank you, Ms. Olson. Are there any objections to admit the rebuttal testimony of the witness? Hearing none, it's admitted.
Mr. Hearing Examiner, we would tender Mr. Schuestel for examination.
Thank you. So going to our order of cross-examination, let's start with Diana County. Mr. Herman, do you have any questions or cross-examination for the witness?
Yes, I do. Thank you, Mr. Examiner.
Please proceed.
Good morning, Mr. Schuestel. How are you today?
I'm good, thank you. Good morning.
And we've met in the past. You're aware I represent Doña Ana County in this matter, correct?
Yeah.
I'm sorry, I didn't get that.
I said, yeah, yes, many times.
And just because I'm in kind of the same boat as the hearing examiners, and I think your attorneys in Santa Fe, downtown Santa Fe may have some capacity issues, particularly I've noticed in the morning. So please let me know if I begin to break up my signal. I wanted to ask you about one part of EP's proposal in this case, the reallocation of the Santa Teresa project. You addressed that several times in your direct testimony, correct?
Yes, I addressed the assignment of the amount that we're requesting from Santa Teresa.
I'm sorry, that we're requesting from,
Santa Teresa, the Santa Teresa facility.
Could you spell Teresa for the court reporter?
Sure, it's Teresa, and it's located in Santa Teresa, New Mexico.
Now, regarding El Paso Electric's proposal to reallocate 100% of that to New Mexico, if I recall, the prices of that PPA were pretty competitive, correct?
Yes, and just to be clear, you say reallocate. This is what we're requesting is the assignment of, or the allocation of the facility to New Mexico. So it's not, what I mean is, and I'm only quibbling on the words because it's not currently assigned anyplace else. It is being assigned to New Mexico.
Could you elaborate that on that a little bit more? Was it always 100% assigned to New Mexico?
Right. Well, the facility itself is currently under construction, so it's not operating. This is the Santa Teresa facility. And so when it becomes operational in 2026, we estimate, at least based on the COD, around the middle of 2026, and it starts operating. Our proposal is that all the energy produced by that facility in 2026 would be assigned to New Mexico customers for RPS purposes, and New Mexico customers would purchase all of that energy. So we've made that proposal for 26 based on our determination that that is how much energy we need to meet the RPS requirements in 2026. What we've said is, as we go forward, obviously, when we get to a full year, for example, of production, it may not be necessary to have the full 100, all of the energy go into New Mexico. So for 2026, we propose that all of it goes to New Mexico because it's really only expected to be operational for half the year. So when we get to 27, in our 27 plan, we'll evaluate how much of that facility needs to go to New Mexico. So it very likely will be a different allocation, less energy from the Santa Teresa facility in 27, but we'll make that determination when we get to our planning next year.
And that determination is based on the RPS requirement in New Mexico statutes?
Correct. It's based on the RPS requirement. It's based on our forecast of New Mexico load.
Now, back when Santa Teresa was approved, was that, I'll test your memory, 190034 UT?
No, I think you might be thinking of a different facility. So the Santa Teresa facility is actually we've offered it in this proceeding for approval in this proceeding. We have a PPA with the developer for Santa Teresa, and it's under construction now. You may be thinking of the Buena Vista facility, which is similar size, and there has been reallocation from Texas to New Mexico of energy from that facility. So maybe you're thinking of Buena Vista.
Possibly. Thank you for that clarification. So Santa Teresa hasn't been approved yet by the PRC.
That's correct.
Now, the Buena Vista project, I believe it was last year's filing, you did seek to reallocate some of that to meet RPS requirements last year, correct?
That's correct.
And that reallocation has taken effect, correct?
My recollection is we did some allocation of energy in 2024, and we are doing the same thing this year in 2025.
So the Santa Teresa allocation, that is to replace the Carne allocation that was approved last year, correct?
Substantially, yes.
So El Paso Electric El Paso spans two jurisdictions, Texas and New Mexico.
I'm sorry, Mr. Herman. Let me clarify my last response. Santa Teresa, the facility was procured actually to substantially replace the Hecate facility. I misspoke. The Hecate facility that was never constructed. There is also the issue with the Kearney facility of a delay in the COD. So I just want to make sure I'm clear. I would say Santa Teresa was substantially procured to essentially replace the Hecate facility that was never built.
Thank you for that clarification. And as you may have noticed, there have been several of these cases that we've all been involved in. So I appreciate it. Let's keep the records clear on this. So anyway, Texas or El Paso Electric has historically split its resources along an 80-20% between Texas and New Mexico, correct?
With the exception of facilities procured for RPS, purely for RPS purposes, yes.
And how many, you know, the total amount of megawatts across El Paso Electric's entire system that are renewable, or what would qualify as renewable in New Mexico?
I'm thinking, and not right off the top of my head. I'd say it's on the order of between 200 and 300 megawatts.
Across the entire jurisdiction?
Across the entire jurisdiction. Mr. Villalobos, I'm sure, could tell you exactly that number, but it's in that range. There's a couple that are currently under construction or in testing. So we're, that number is increasing more rapidly every year, but I would put it in that range, 200 to 300 at this time.
I guess my ultimate question is as we keep talking about allocating more energy across El Paso Electric system to New Mexico, why are we stopping here? Why don't we just allocate all the renewables to New Mexico? And I'll leave it at
that. It's a fair question, although as you referred to, there are some system resources, meaning renewable resources, and Buena Vista is one of them, for example, that was actually procured for purposes of serving both jurisdictions. So we have a combination right now of some system renewable resources that serve both Texas and New Mexico, and then we also have facilities that serve purely New Mexico renewable facilities. And so there has been that issue of allocating differentially, I would say, allocating more to New Mexico to fill a gap as we add more resources for New Mexico. But the goal here is to eventually get to the point where we have sufficient resources from a renewable resource perspective to meet our RPS compliance and in New Mexico and not be moving resources around between jurisdictions from year to year.
That's the goal, but we have, I'd say, 2 years now where we're seeking to allocate additional solar resources, even though arguably they'd be system resources, correct?
That's correct. I mean, I think that this situation is driven substantially by difficulties in bringing some facilities online during the period around the COVID epidemic, and then thereafter with all sorts of difficulties with supply chain and other things. I think we're coming to the point where we're really moving out of that issue. Hecate is a perfect example of, had those two facilities, Hecate and Buena Vista, been brought online fully on the expected CODs, we wouldn't be reallocating energy today. And so as we move out of that period of time, we're seeing solar facilities being brought online more reliably now, and I think we're pretty much on the trajectory to move out of that period.
Well, then we also have the delays associated with Carne, correct?
Yes, that's true.
And
It's the last one.
So I guess my ultimate question is this going to be the last time we just see, more of a paper renewable proposal rather than a constructive? And what, do you know how this is going to look in next year's RPS filing and the year after that?
Mr. Hearing Examiner, I'm gonna object to the question, and particularly the characterization of a paper renewable. EPE is seeking approval of a new renewable resource in this case, so I don't think that characterization of a paper renewable is accurate.
Yes, I would agree with Ms. Olson. Did you have another objection, Ms. Olson?
No.
Okay, thank you. Mr. Herman?
If I may respond, when I refer to that, I don't just mean the proposal here with Santa Teresa, but other past instances where it has just been a straight reallocation proposed.
Mr. Hearing
As I
Examiner,
stated, Carne and Buena Vista. Thank you.
Mr. Hearing Examiner, I would then modify my objection to the extent Mr. Herman's raising issues with proposals and past plan years are simply not relevant to this case, and the Carne project, like the Santa Teresa project, was a RPS procurement approved in an RPS case. Leave it at that.
Okay. Mr. Herman, would you like to proceed?
No, I think my point has been made. And I don't, well, let me just re-ask this question, in the sense that, Mr. Schiestel, do you know, what your RPS filing is going to look like in 2026 and 2027 moving on?
I have an idea. We are, as I said, more confident today in the dependability of commercial operation dates. I think we're learning as we go. There's obviously no planning for certain events, but I think that we're positioned pretty well to. We met our for example, we met our RPS requirements in last year, the 20%. My expectation is that we will reach 40 for 2025. It's still requiring some moving around of resources, but with Kearney and Santa Teresa coming online next year, and even with expected increases in our retail load, I believe we will be meeting that requirement in 26. And then I think as we go forward into the future, we're well positioned for bringing resources online for purposes of not only RPS but just serving retail load. I say in my testimony, we talk about expectations for increasing load over time. That will be a challenge, but I believe that we're well positioned to have adequate resources for RPS purposes, and even more importantly for just retail service. But that's my expectation for 26 and 27.
So are you able to commit today that the future RPS filings aren't going to involve proposals to reallocate currently existing renewable resources?
Mr. Hearing Examiner, I'm going to object to this question as outside the scope of this hearing. We're here to discuss EPE's filed plan for compliance in 2026. Anything beyond that is simply outside the scope of this hearing.
I'm going to overrule that. I think that the company's practice with respect to reallocation in past and future instances is relevant to this hearing.
You need me to restate that question?
No.
I don't think so. I think, as I said, my expectation is that we'll meet the RPS requirements, and to do so with the resources that we're procuring specifically for New Mexico. I can't guarantee in the future that there won't be instances that complicate that, but I will say our planning at this point is to not only be meeting our annual RPS requirements, but to procure resources to get ahead of those requirements. As you know, we just crossed the 40% threshold in 25. It goes up to 50%. That's right around the corner. So we are, I think, been pretty successful at accelerating getting resources online. So I have a lot of confidence in that. But I can't predict the future, and so there's always the possibility. But that's not the practice that we want to continue.
Thank you. And just one last question regarding the Santa Teresa costs. Will the energy produced by Santa Teresa, or the cost of the Santa Teresa facility, be offset by reduced fuel purchases for other generation?
Sorry, I'm looking for that.
I'm sorry, I'm not hearing you. Please repeat that.
I apologize. I was looking through my testimony real quickly for the price, but I'm not finding it. But it's not important for the answer. It will be offset by a reduction to non-renewable fuel costs. The extent to which how much it will be offset is then a function of those costs. So the solar price for Santa Teresa and for most facilities is fixed, and so the hedge against non-renewable fuel costs is beneficial to the extent that those fuel costs are higher. So our fuel and purchase power monthly adjustment essentially allocates energy between jurisdictions. And New Mexico's allocation is first adjusted for these directly assigned resources. So as more and more RPS resources provide energy for New Mexico, less energy is supplied from system non-renewable resources, and so less of that fuel cost is allocated to New Mexico. So there is a replacement, but the extent to which there's an offset is really a function of future gas prices.
Thank you very much, Mr. Schiessle. I appreciate you answering my questions today.
Thank you.
Thank you, Mr. Herman. Going next in our order of cross-examination, we have Ms. Lynch. Ms. Lynch, do you have any questions for the witness?
Yes, I have a couple of questions. Referring to what you provided to Mr. Herman right now, please clarify if I heard correctly. The Santa Teresa facility and all of its production will be allocated to New Mexico customers for this year, correct?
Yes, the solar production. So the Santa Teresa facility is 150 megawatts of solar production and 150 megawatts of battery energy storage. Our proposal is to allocate all of the energy produced by the solar facility to New Mexico this year for the months in which it's operational, which is expected to be about six months of the year, and to also assign to New Mexico 50 megawatts of the battery energy storage at Santa Teresa
For this year.
for this year.
The potential exists to allocate some of the energy produced at that facility to Texas in future years, correct?
That's correct.
Do you need to seek approvals from the Texas's equivalent commission for the production of energy from those facilities to allocate that energy to Texas?
Yes, but the approval process is different in Texas. So in Texas, for example, for a PPA, as this Santa Teresa facility is purchased under a PPA, what we'll do when the system begins operating is we will allocate Texas, whatever portion is determined that we're going to allocate to Texas, we'll allocate that to Texas, and it'll start appearing in Texas fuel reports. And then the approval of that allocation of costs essentially happens in fuel reconciliation proceedings. So we have a fuel reconciliation proceeding every 2 years in Texas. And so in the fuel reconciliation following the commercial operation of Santa Teresa, assuming we allocate a portion of that energy to Texas, then that would be considered and approved in the fuel reconciliation proceeding.
Okay. What entity owns Santa Teresa?
Santa Teresa, the Santa Teresa facility is being developed by, we've referred to them as DESRI. It's D.E. Shaw Renewables.
Okay.
Can I just
Appreciate
ask
it.
a clarifying question? Mr. Schisto, you said it's being developed by, I think Ms. Lynch asked who has title to the property or to the facility.
Sorry, D.E. Shaw is the owner, is the developer and owner of the facility under the PPA.
Okay, thank you.
Does the facility produce solar that can be used immediately, and then any excess energy is stored in the battery, or does the facility produce and store directly and then energy gets used?
The facility can export all of the solar energy being produced. It can also store some of that energy and export, the part that's not stored. It can also store all of the energy being produced and then export it later from the battery. So it really has a lot of flexibility in terms of how it puts energy onto the system.
Thank you for that explanation. Hearing examiner, that's the extent of my questions for Mr. Schisto.
Thank you. I don't suppose, Mr. Begacco, do you have any questions for the witness?
I do.
Please proceed.
Thank you. Good morning, Mr. Schiestel. How are you?
Good. How are you?
All right. Well, while it's fresh in mind, I do have a couple follow-up questions about your allocations. I think many of the ones I had before been answered, so I'll
I'm
try to
sorry,
keep it short. If I
I'm
would
missing
direct your
you.
attention to page 10.
Mr.
Mr.
Bogatko?
Bogatko, I'm sorry, I missed that question. I think many of the ones I had before you just cut out, for me anyway.
Oh, look at that. How are you hearing me now?
I'm
Just
hearing
when I
you.
want to talk, my internet
know.
starts messing. Okay. I will start over again. What I was saying was I wanted to follow up with a few questions to Mr. Schiestel about differential allocation. And I was directing his attention to page 10 of his direct testimony. I'll give him a moment to get there.
All right.
All right, Mr. Schiestel, there on page 10, lines 14 through 16, you say acquisition of system, renewable resources, those serving both jurisdictions has provided EPE the ability to differentially allocate more resources as needed for New Mexico. Did I state that correctly?
Yes.
Now, the part of your testimony that interests me even more is the next sentence, which reads, the ability, however, is limited once the PUCT approves a system resource for rate-making purposes in a general rate case or a fuel reconciliation proceeding in Texas. Did I state that correctly?
Yes.
And to be clear, PUCT stands for Public Utility Commission of Texas, does it not?
That's correct.
Do they still call it the Railroad Commission sometimes?
There is a separate commission, which is the Railroad Commission.
Okay. Texas is its own country, I understand. So I'll leave it at that. But based on some of the questions that you answered in response to CCAE here a moment ago, you talked about the point at which maybe your ability to differentially allocate stops being then what, a PPA proceeding in Texas?
A fuel reconciliation proceeding.
I'm sorry,
Okay.
repeat your answer, Mr. Schiestel.
I clarified, I was asking if Mr. Bogatko meant a fuel reconciliation proceeding.
Well, I think that goes to the heart of my question then. I see there basically where you list two things that basically halt the ability to differentially allocate, those being in Texas, a general rate case or a fuel reconciliation proceeding. So then based on your prior answers to Ms. Lynch, am I to understand that the crystallization of a PPA in Texas is something that is inherent to either a general rate case or a fuel reconciliation proceeding, or is it a separate proceeding that halts the ability to differentially allocate? Sorry for the long question.
No, that's all right. I understand the question. I use the word limited, that the ability is limited once the PUC approves a system resource, and it isn't foreclosed. And I'll talk about, we have a proposal going back from a prior RPS proceeding about a facility in Texas. But the process in Texas, once I described, for example, the fuel reconciliation, where at some point we're receiving energy from a facility and we are in a fuel reconciliation proceeding. And at that point, where we have to essentially, at that point, the commission is essentially approving the provision of that energy at that price to Texas. So it's not really a PPA approval so much as an approval for the energy being supplied under the PPA. The reference to a rate case is important also because Texas, certainly in a situation where a facility has a battery, the approval mechanism then for battery storage, much like New Mexico, in some cases is a base rate proceeding, because the cost of the battery, or the cost of the battery would be addressed in the rate case proceeding. So what I'm saying here is that when a facility comes online like Santa Teresa, and I haven't yet taken energy to Texas and gotten approval for that energy in Texas, the ability to say, okay, I'm going to temporarily assign some energy. This is the Buena Vista situation. I'm going to temporarily reassign or assign more of that energy than I otherwise might. to New Mexico because I haven't yet taken it to Texas. The reference here is once I've done that, once I go to Texas and say, okay, I'm providing this power, and they approve the provision of power and the cost recovery from Texas customers, it's much more difficult then to say, wait a second, I'd like to send some to New Mexico. So the Macho Springs facility, which is a subject of, forgive me, it may have been last year, the year before's RPS proceeding, was specifically to say we're going to take some energy from the Macho Springs facility, which is a 50 megawatt solar facility that is already being provided to Texas and is already approved for recovery in Texas, but I'm going to allocate it to New Mexico instead for a period of time to meet my RPS requirements. In fact, that's proposed for this year. The difficulty is in that situation, I have to get Texas approval to do that. So it's more complicated. And we're in a proceeding right now in Texas to get approval for that Macho Springs reallocation. But that's what I mean when I say at some point it becomes much more difficult to do that reallocation.
Do you recollect the case number in Texas for the Macho Springs allocation case you just talked about? And if not, I can figure it out myself, but I thought maybe you might have it top of mind.
Yeah, I wish I could say I did, but I don't.
Fair enough. I can get it other ways, and I appreciate your willingness to entertain the question. Now I will direct your attention to the paragraph above what we were just looking at on page 10. And there in that paragraph, starting on line 6, you are giving us a bit of a history lesson. You say, historically, EPE has procured generation to serve customer load on a total company basis. And EPE's customers have benefited from this total company approach because of increased diversity, etc. My question to you then is, when did that total company basis approach cease? Was it with the advent of the Renewable Energy Act in New Mexico, or was there something else that represents the historical cutoff for that era?
I would say that it hasn't stopped. In other words, there's not a clear end to that, and certainly we still have the opportunity to do or to procure system resources and allocate them get approval for them both in jurisdictions. The RPS and the differing policies between Texas and New Mexico, and specifically the RPS, has complicated that. And as the RPS requirements increases, I say that's where you're seeing this divergence between the two states. The Buena Vista facility and the Hecate facility, for that matter, were procured for purposes of both jurisdictions. It was a system resource. It was procured as a system resource to serve retail load, and is allocated between the two jurisdictions. It wasn't specifically procured for RPS purposes, but obviously it provides renewable energy to New Mexico, and so it qualifies for RPS. I could see that situation in the future happening, another solar facility being split between Texas and New Mexico. We're talking about Santa Teresa right now, being potentially allocated between Texas and New Mexico. The difference is where the divergence is happening is that with the Santa Teresa facility, I'm making an allocation based on perhaps what I need in New Mexico and Texas, as opposed to just a pure proportional allocation between the two jurisdictions. So what I would say that divergence pretty much started after Buena Vista, and it's happening now. But our ability to procure system resources is not foreclosed. It's complicated by the policies between the two states. I expect it will be happening less, but it as I said, it's not foreclosed completely.
Do the complicated policy differences between the two states affect the economics in comparison to the way it used to be done on a total company basis?
I say it can affect the economics. For example, because New Mexico's service territory is roughly a quarter of the size of our Texas service territory. If I'm procuring a renewable facility, for example, for New Mexico, it will more than likely be smaller than if I was procuring it for the entire both jurisdictions. And so there's some economies of scale there that can affect the price. But I don't believe that's substantial, but that is happening or can happen, I should say.
Okay. Moving along, now I would direct your attention, Mr. Schiestel, to page 16 of your direct testimony. And what I'm interested in starts on line 9 and runs through line 14.
I have that.
Okay, so, well, I'll truncate it a little bit. Starting on line 11, you make a pretty interesting statement, and it reads as follows. This is the fundamental impact of the REA and RPS requirements. The move to clean resources may be beneficial on a cost basis only if the resources replaced were of higher cost, but the customer benefit is a cleaner portfolio over time. Did I recite that correctly?
Yes.
And you've placed emphasis by bolding and underlining the word may and bolding and underlining the word but. Is that correct?
In my version, no. I don't. I apologize.
Oh,
I don't. At least
maybe that's me. I'm sorry. That's me. I'm looking at my notes, and sorry for that. It was important to me. So let me back up there. Scratch that. My foul, mea culpa. But all right, so you qualify it as the move to clean resources may be beneficial on a cost basis only if the resources replaced were of higher cost. So are you saying that the value of the REA and RPS requirements is what, significantly or moderately conditioned by the things that it replaces being more expensive? I mean, can you explain or expound on that a little bit? Is this I see you're trying to qualify it, but I'm trying to understand the extent of your qualification and what is, I believe, to be implicit in this statement, if you would.
certainly. So the financial benefit of the potential financial benefit of renewable energy facilities.
I'm sorry, Mr. Schiestel, could you repeat the last thing you said? I couldn't quite hear you.
Sorry. So I said that the financial benefit, the potential financial benefit of solar or renewable facilities is that they have no fuel costs. They have upfront capital costs, but they have no fuel costs, unlike traditional generation, which has both. So I see renewable purely from a financial perspective. I see the choice of renewables as one aspect of it, as a hedge against variations in fuel costs for your non-renewable. So, for example, what you're avoiding, as I say earlier in this statement, what you're avoiding as you increase the amount of renewable energy that's being supplied to the system with no fuel costs is you're replacing non-renewable or traditional, in this case, let's say gas-fired and nuclear, in our case, facilities. And so you've now hedged against fuel costs changes. So, for example, when fuel costs are very high, that is a beneficial financial hedge, meaning you're replacing the cost of fuel with essentially a fuel cost-free facility. But if costs are lower, it may be the reverse. But and my last sentence there was basically saying, but if it is the case that you're replacing, say, a cheaper resource with your more expensive renewables, you are getting the benefit of the renewable resource, which I think is the whole point of the REA, is to have the clean portfolio, not necessarily one that is absolutely guaranteed to be a lower cost, but it is one that is very competitive on cost, but it's a cleaner portfolio.
And then when you present this proposition or this statement, when you formulate it in your mind, does that include also the financial consideration of batteries, which seem to be an unavoidable facet or a companion to the procurement of renewable resources?
Yes, I think that the addition of storage with resources that are non-dispatchable, like for example, in our case, predominantly solar, but wind as well, is that if they you have the ability to make them more like a dispatchable resource. So, for example, Santa Teresa, as in response to an earlier question, I described how the energy can just be produced and exported onto the system, or it can be some portion or all of it can be stored and exported later. So essentially you're doing is you're changing the output profile of this non-dispatchable energy generation to the time periods where you need it more, and that's the purpose of the storage. One purpose of the storage. And so it becomes more like a traditional dispatchable resource. And I think that's an extremely important aspect of renewable energy to ability to become a bigger part of a portfolio.
Okay. And then just following on that, right now, with your current knowledge and familiarity with the lay of the land, if you're just to do a bimodal comparison between renewable generation paired with batteries versus traditional generation, which in your mind is currently more economically feasible?
They're both economically feasible, but with gas prices as they are today, operationally, gas-fired generation is at least, yes, gas-fired generation is more than likely still below the cost of the cost of renewables.
But would you be able to say at least that renewables paired with battery as a procurement proposition are economically competitive, though? Are they poised to be or not?
Well, as I said, I'll just give an example. The answer is yes. We fairly recently completed an RFP for resources in Texas, or Texas resources, for much more capacity than we would say be procuring for New Mexico. So a large amount of capacity and energy for Texas in what's referred to as an all source RFP. That is, any type of generation can participate, and the selection is going to be substantially on the basis of price. Obviously, the selected facility has to be able to provide what you need, but assuming you have all the bids for different facilities that can provide what you're asking for, the difference or the differentiating factor will be the price. In that RFP, we selected all renewable and battery storage facilities. So they're all selected in a competitive solicitation. Now, in the RFP prior to that, we had selected a gas facility, and I still expect that in the future, gas facilities will be selected in competitive RFPs. But just as an example, in this most recent Texas all source RFP, it was all solar and battery storage.
Thank you
Let
for
me
that context.
Mr. Bagacco, Mr. Shisto, let me just interrupt for a second. We're at 10:16, and I want to be conscious of the efforts of our court reporter and maybe all of us as well. Why don't we take a 15-minute break and come back, and Mr. Bagacco can resume with his questions. Does that sound good to everybody?
Yes, please. Thank you.
Okay, thank you. So we're in recess and off the record at 10:16, and we'll be back here at 10:30. Thank you, everybody. Okay, everybody, it's 10:30. We are back on the record in case number 25-00038 UT. Mr. Begacco was in the midst of cross-examining EP witness. But just before we resume the cross-examination, I'll say that we will continue again for about an hour and 15 minutes. At that time, we'll break for lunch, and we will break for lunch for an hour. But I just wanted to preview that as we continue with our testimony and examination here. So, Mr. Begacco, would you like to resume your line of questioning?
Yes, please. Thank you.
Thank you.
All right, Mr. Schiestel, I think we can move on to the next couple questions I have, and I'll try to wrap this up here pretty shortly. Thank you for bearing with me. Page 17 of your direct, where you talk about CRLEF, if you would go to that, please.
On there.
All right, just to unpack this a little bit, there on line 13, you talk about the Camino Real landfill to energy facility being a qualifying facility operating near Santa Teresa. Did I recite that correctly?
Yes.
Okay. So basically, CRLEF is trash gas, right?
Yes, it's a 2 methane generator ship.
And then when you talk about,
I'm sorry, a methane generated.
It's a yes, 2 methane generators.
okay. And you talk about it being a qualifying facility or a QF, correct?
Correct.
Can you tell us what is a qualifying facility in this context, please?
For this purpose, qualifying facility essentially means it's a facility under which I'm under FERC rules. I'm obligated to purchase energy from at avoided cost.
Okay. And do you know where this qualifying facility concept originally came from? Was it perhaps something called PURPA?
I believe so. I don't have a clear recollection, but I believe so.
Okay. And for the record, that would be the Public Utility Regulatory Policies Act of 1978. Does that ring a bell with you, Mr. Schiestel?
Yes.
Okay. Well, there at the bottom on page 17, you talk about how this QF that's been providing landfill gas as a renewable energy resource stopped generating that power and is no longer selling to EPE. Do you see that down there on lines 20 and 21 of page 17?
Yes, I see it. That's correct.
Okay. And I'll warrant to you that I read Mr. Villalobos' testimony also, and he said something about this facility being sold as factoring into why it stopped selling to EPE, and then he punted it over to you to discuss. But I don't see where you discuss the sale there as a factor, so I wanted to follow up with you on that. What happened to this QF, and why aren't they still selling you the landfill gas as a renewable energy resource?
Yes, the facility was sold. That's my understanding, although I don't have a lot of details on the sale. And they did cease operation, at least from the perspective of producing energy and exporting it to the system. They're still an operational facility as a landfill, but they're not operating their generators. My assumption, and this is pure assumption, is that they made the decision to stop because it wasn't economic to do so, and perhaps they had a better use for the methane that's being produced at the facility. That's my assumption, logical assumption. But that's about all I have on CRLEF. It's been operating for a long time. It had issues early on with respect to it's not methane is not as I understand it, not a great gas in an internal combustion engine. You have to blend it with other gases, I think, and so it's difficult to operate. But they were operating very well with that about 3 megawatts at the facility, but it may very well be that they just changed their business model when they were sold and made that decision to no longer produce power.
Thank you. Was CRLEF the only QF that you had who was contributing to your renewable energy portfolio?
I believe that they are the only large QF that we have. We essentially treat and I believe they're considered all rooftop generation, for example, or solar generation at commercial buildings. The city of Las Cruces, for example, has rooftop and other solar facilities providing power. Those are all considered QF. We have the same obligation for purchase of the energy, and they add up to quite a bit. But certainly CRLEF was the largest.
I understand. But do those other QFs count towards your RPS compliance, like CRLEF apparently did for some time?
They do for the energy that's purchased from them at avoided cost as a QF.
Okay. Well, thank you for the background on CRLEF. I'm going to try to get to the end of this. In your testimony, you talk about the prospect for new large load to materialize on the system. For example, on page 24, lines 3 through 4, you talk about the increasing probability of adding new large load customers to the system. I'll give you a moment to get there and look at it and let me know whether or not I misstated that.
I have that. That's correct.
And you preface it with that declaration that Epe'S New Mexico jurisdiction needs additional capacity now and in the future with the increasing probability of that new large load. And that would be lines 2 through 4 on page 24.
Yes.
So when you get new large load, you have to consider the impact on complying with the RPS standards prospectively, correct?
Generally speaking, any additional load. So just to back up one little bit, one of the things that we've had to address in the recent years is increasing growth in New Mexico, just on customer growth and energy sales. And so since compliance in RPS is a percentage of your energy sales, as you add customers, that requirement increases. Even if the percentage, our RPS percentage stays the same, the requirement for renewables increases. With the large load customers that we're talking about specifically, and what we're seeing interest in, and it can be, I think, characterized as data center load or a large manufacturing loads that operate at a higher load factor, meaning they require more energy per megawatt of demand. It pushes that requirement even further. So a new large customer operating at a high load factor is really going to add energy to your retail sales, which puts pressure on your RPS compliance, because it's that much more increasing amounts of renewable energy that you have to procure for purposes of compliance.
And following on that same page 24, lines 14 through 15, you characterize it, Lee, in a slightly different way in terms of Epe'S New Mexico jurisdiction is going to compete for new large loads in the near term, my emphasis. So that is your understanding? It's a near term proposition at this point?
So again, referring specifically to what we're seeing, utilities all across the country are seeing in terms of interest of data center load. One of the characteristics of that interest in our service territory and other service territories is how quickly that load can get online. In other words, how when can you serve me? When can you begin serving me? And speed and time is a very important aspect of the decision of a data center, for example, to locate in a particular area. So I use that reference in the near term because essentially, at some level, the customer is only going to exist if you can get them online in the short order. If you tell them I can serve your load in 5 years, they're just going to go somewhere else. So the load's not going to materialize. So the interesting aspect of all of this with respect to customer interest is really, I'm going to locate in your service territory, but you have to be able to serve me in the next year, 2, 3 years at most.
I've seen some news lately and in the last few months, and I understand that there's something developing and that you perhaps have a large load customer perched on your doorstep, so to speak. Is that a fair characterization?
Yes, in Texas at this point, yes.
In Texas. What about New Mexico?
There's expressed interest in New Mexico as well, all across our service territory. The Texas will probably be first, but it certainly won't be the last.
For New Mexico, do you have any stats you can share with us about how large of a load it might be approximately from whoever's expressed interest, just for purposes of the exercise of, I don't know, projecting what the impact might be on the back of an envelope right now for RPS compliance going forward?
Well, what we've included, I'll just say what we've included in our load forecast for New Mexico and what is driving right now the expectation of increasing RPS requirements in New Mexico, especially in 2027, is an initial interest of 80 megawatts, 80 megawatts. So in context, that's about 4 times our largest customer in New Mexico today. And generally speaking, that is the going in capacity for a data center is to begin at that level and then ramp up over a couple of years to their full requirements. And 200, 500 megawatts is not unusual. And so I'll just leave it at that. We certainly have that expectation with New Mexico, and that's what you see in this application with respect to with load requirements in 27, 80 megawatts.
Thank you for that. And then finally, I would direct your attention to page 28 of your direct testimony. Lines 9 through 11.
Okay.
And there you talk about the variance that's been requested in reference to minimum data requirements for Rule 17.9.530. Can you tell us for the record what 17.9.530 is?
It is literally, as it's said there, the data schedule requirements for rate making proceedings, as I understand it. And those requirements are pretty extensive. So while they are understandable from a general rate case perspective, they're more extensive really, and our request for the variance is based on the belief that they're much more extensive than is necessary for, say, approval of the RPS cost rider, the rate that we're setting or requesting to set in this proceeding. And that's the basis for the variance.
So is it fair to state that the requirements implicit in 17.9.530 or explicit, are you saying it's overkill and really wouldn't be useful? Or are you saying that you just simply don't have the number and quantity of schedules that would actually be responsive to what's contemplated by Rule 530?
I think primarily we're saying I wouldn't characterize it necessarily as overkill, but it's certainly information that isn't necessary for the approval of that rate, for example. And so that's the basis for the variance.
All right. Well, thank you for helping staff to understand some of these things a little bit better that we see in your direct testimony. And with that, Mr. Hearing Examiner, I would pass the witness. Thank you, Mr. Schiestel.
My pleasure. Thanks.
Thank you, Mr. Bagatko. I believe next on our cross-examination order list is the Coalition for Clean, Affordable Energy. Ms. Lynch, do you have any questions for the witness? Ms. Lynch? Ms. Lynch may be momentarily indisposed. I would like to ask some questions in the meantime. And then if Ms. Lynch joins us again, maybe she could proceed with her cross. And then at that point, I think we may be ready for any redirect from EPE Council. Mr. Schiestel, thank you so much for being here with us today. I just have a couple of questions to follow up on some of the testimony that has been provided in writing and also here verbally. And one of the questions I wanted to ask is, what other sources of renewable energy did EPE consider in its search for more renewable portfolio standard capacity? Was this the only type of energy that they looked at, or did the company do a cost-benefit analysis on various other types of energy, as opposed to paying for a new facility in Santa Teresa?
So for El Paso, solar generation is the predominant renewable energy source. And Mr. Villalobos can flesh this out a little bit more, but my recollection is that we did in the competitive RFP solicitation that we did for the resources recently that produced the Santa Teresa facility. Santa Teresa was selected from the bids in that competitive solicitation. There was a bid for wind, as I understand it, and there may have been more, but I'm pretty sure there was at least one. So wind is a occasional participant in our service territory, but because of the nature of wind and as I understand it, it's characterized as our area does not have good wind resources. Wind is typically has to be paired with pretty significant transmission. So southeastern New Mexico, some parts of New Mexico have much better wind resources, but in order to get that into our service territory, it would have generally required transmission, which makes those, when you have to pair those two things together, the generation resource and the transmission, it makes them more expensive than, say, competing solar resource that can be built right in our backyard.
Sure, thank you. My next question relates to the structure of the relationship between El Paso Electric and DESRI, I suppose. Now, you have stated that the Santa Teresa facility is not constructed, right? It's just exists right now as a planned project. Is that correct?
It is under construction, but it's not completed. That's correct.
Okay. Now, has El Paso Electric contributed any capital to that project, or is the relationship merely contractual with respect to the PPA?
It is purely contractual through PPA.
Okay. Now, can you just describe for us generally the structure of the RPS rider and how you see that the cost here from the Santa Teresa facility being recovered in the RPS rider?
Certainly. In our rider, we set a rider every year to recover all of the costs associated with the facilities that are providing RPS resources, meaning the resources that are supplying energy to New Mexico and have been approved in RPS proceedings, and specifically are essentially complying, or facilities procured to comply with RPS. Those are substantially all, for us today in New Mexico, substantially all PPAs. And so what is reflected in our calculation for the rider, which Mr. Gonzalez presents in his testimony, is the estimate of the cost of power for the plan year. So in this case, 2027. We estimate the cost for all of the resources that will produce energy for RPS purposes in the plan year based on expected production and the PPA price. So the PPA price is fixed and set, but the production of the facilities, and that price is a per megawatt hour facility price, the output of the facility, the amount of energy that's actually going to be produced, is obviously unknown. And so it's estimated. We calculate the cost based on those estimates, and we get to a full cost expectation or forecast for 2026 for RPS purposes, and then divide by expected sales in 26 to get to our RPS rate. That rate includes the expected cost of all facilities that will be providing energy and battery storage as well. So the Kearney facility, when it's completed, will have a battery component. The Santa Teresa facility, if it's approved, has a battery component. All of those costs are incorporated in the RPS rider. The RPS rider also is adjusted every year, in addition to the projected costs that it's for RPS compliance resources. It is adjusted every year for the difference between what we projected the cost would be and what they actually turned out to be. So as I said, there is some forecasting involved in setting the price, because you're not only forecasting the output of the facility, you're forecasting your retail sales, over which you're going to recover the cost. So what we do is for in this case 2024, we look at, okay, what are our actual costs? How much do we actually produce from those, or how much was produced from those facilities at the PPA prices? And how much did we actually sell in retail sales, meaning how much did we recover in revenue under the RPS rider? And then we reconcile that difference in the 26 rider. So the 2026 rider, as described in Mr. Gonzalez's testimony, includes both the estimate for the cost in 26 for RPS resources, but also the reconciliation of 2024. I believe we had an over recovery from in 2024. That's reflected in the 2026 rider as well.
Thank you. Yes, I'd like to talk about that over recovery here in a minute. And I suppose that you have a PPA contract with DESRI, or is that under negotiation, or has it been finalized?
We have a final contract with DESRI for the Santa Teresa facility, yes.
And was that contract included in the materials in your application?
I apologize, but I don't think so. I don't recall exactly, but I don't believe that we submitted the contract, no.
Okay, would you submit that?
Mr. Hearing Examiner.
So, go ahead, Ms. Olson.
Oh, I apologize for interrupting. Mr. Schustel may not be aware of this, but it's attached as an exhibit to Mr. Villalobos's testimony.
The PPA contract? Thank you.
Both the PPA and the ESA.
Thank you. And Mr. Schustel, is that contract contingent upon the approval specifically of the rate rider in this case?
My recollection, and this is a great question for Mr. Villalobos, because he negotiated the contract, but my answer is no. I believe the PPA between EPE and DESRI is for purchase of the energy from the facility, not contingent on commission approval. Now, obviously, if we didn't have PRC approval for the energy and capacity for New Mexico, we couldn't recover the cost from New Mexico. But we are, as I understand it, and I would suggest you ask Mr. Villalobos this question, but my understanding is that we're contractually obligated under the PPA with DESRI for purchase of the energy from that.
Yes, well, that actually leads to my next question: is what arrangements or what has El Paso Electric done to provide for the scenario that the commission does not approve a rate rider? And what I mean is how that will affect New Mexico ratepayers.
So just to clarify, do you mean doesn't approve the rider to incorporate Santa Teresa? In other words, the commission doesn't approve the Santa Teresa facility? Because the rider is already approved. I just want to clarify, so I'm answering.
That's correct.
So I'm trying to recollect if we've had this situation. We've certainly had complications or challenges to additional facilities in the past. I don't believe we've had, at this point, from an RPS, renewable resource perspective, ever had this situation where we made a proposal that was rejected. But generally speaking, as I said, the contractually we're obligated with DESRI for purchase of the energy from the facility, and we would essentially need to find a home for it. Obviously Texas is our other jurisdiction is an option. The effect on New Mexico ratepayers, let's say, just for sake of argument, the effect on New Mexico ratepayers of, for example, saying no to the Santa Teresa facility simply means that in order for EPE to maintain compliance, that we'll have to find another facility to serve New Mexico, some other source for renewable energy for RPS compliance. Now, Mr. Oliver testifies about the expectations about prices and other things with respect to renewables, but let's just assume that going forward, at least in the near term, you're seeing cost increases. Then the effect on New Mexico ratepayers of another facility would depend on what those prices are, and you may very well end up with a higher price facility a couple of years from now when you're able to procure a replacement for Santa Teresa, for example.
Yes, thank you. I guess what my question is that if the costs of the PPA for the Santa Teresa facility are not allowed to be included in the rate rider, how would El Paso Electric recover those costs? Would it is the company prepared to include those in a traditional rate case or in some other mechanism?
That's an option. I can see. In other words, if the situation you're describing is that the commission in this proceeding does not approve the Santa Teresa facility for RPS purposes, it is certainly possible that EP could bring it as, for example, for LTPPA approval, long-term purchase power approval, to go that route. A rate case, of course, is an option. So it could be taken. The contract itself could be taken to the commission under different circumstances or a different proceeding. But I can't say that I know what we would do in that instance.
So no contingent or no planning has been taken by EPE to deal with such an outcome. Is that correct?
I think that's correct. I don't think we've considered, for example, I think that would be really, that determination would be based on the reason for the rejection. For example, if the commission said no to the facility on the basis of hypothetically price, then it doesn't seem to me that taking it to a different venue, to New Mexico, to taking it back to the commission would make sense. If it were an issue with the RPS rider, for example, versus the recovering the cost of the PPA through fuel, which was which was done for RPS resources before we had the rider approved, that may very well be a different answer. I think if the response was from the commission is essentially, I'm fine with the facility, but I don't want it in the rider, then FPPCAC may be through a long-term power purchase agreement approval, and then FPPCAC might be the alternative.
Okay, so another question that I wanted to talk about was if I understand correctly, the RPS rider, the application is to include costs in the RPS rider that are allocated to New Mexico. Is that correct?
Correct.
So there'll be costs of this purchase power agreement that are not allocated to New Mexico, and presumably those will go to Texas ratepayers. Is that correct?
Potentially. Yes. potentially.
So what do you mean potentially? Can you explain what you mean by that?
Certainly. So I'm thinking of, as I said, in 20 for the 2026 rider, our proposal is that the all of the costs associated with energy produced from the facility in 26 go to New Mexico. All of the energy and the costs go to New Mexico customers in 2026, and as well as the costs associated and the capacity of the 50 megawatts of the battery installation also be allocated to New Mexico. So in 2026, that leaves a 100 megawatt battery that isn't assigned anywhere. And in 27, we've basically, as I said earlier, and what we've asked for in this proposal, at least from a next plan year perspective for 2027, is that we'll make the determination of how much of the facility we would want to allocate to New Mexico for 27 when we have a better idea of what our requirements will be. In other words, when we have a better idea of, for example, the availability of other resources like Carne, and the forecasted load for 2027. As I talked a little bit about the potential for large loads coming to New Mexico, that could dramatically change our RPS requirements. And so those are the variables I think that are unknown and need to be considered before we say for Santa Teresa, this is what we're going to do in 27. And that's why this notion of flexibility around the facility itself and how much is going to New Mexico was part of our application.
Yes, that's right. So I guess if I'm understanding correctly, if there's a industrial boom in southern New Mexico, and the full capacity of the Santa Teresa facility could be sold to New Mexico ratepayers, then those costs would be recouped from New Mexico ratepayers through the RPS. Is that correct?
That would be, as I sit here today, that would be my expectation, is that under some set of circumstances, I could see for the 27 plan year saying, I need all of the Santa Teresa facility for New Mexico. At that point, obviously, it has to also have to be approved by the commission. But I could certainly see a circumstance where I'm proposing that Santa Teresa be a New Mexico facility entirely.
And is EPE asking for unlimited flexibility with reallocation between the jurisdictions?
We're asking for some flexibility around 2026. And then the flexibility, I guess you would say, for 27, typically what we've done with RPS resources is when we bring them to the commission, the entire facility is assigned to New Mexico. And then going forward, there's no question about how much from that facility is going to go to New Mexico. We're in this position with Santa Teresa where, at least as we sort of sit here today, maybe we don't need the whole facility for New Mexico for RPS purposes, but it's conceivable that we might. And so the flexibility issue is really around that. I want to make a proposal for 2026 that may or may not extend to 27 and 28, a permanent, let's call it a permanent allocation. And so the flexibility is really about not making that decision just yet in terms of, as we have done with the facilities before, it's just saying that the whole facility is New Mexico. But so we're sort of hedging our bets a little bit on this year and next year before we make that determination.
Sure. So what I'd like to ask you is that how would, if for example, in the scenario, some amount, there's no demand for it in New Mexico, or there's not a significant growth in load, how would that affect the costs that are being proposed to be included in the rate rider here in this present case? What I'm asking is, would the cost, because the cost, if I understand correctly, of the rate rider, or the cost of the PPA that would be included in the rate rider, depend on the percentage of allocation to New Mexico. Yeah. So if that percentage changes, is EPE committed to or prepared to come back to the commission and say, our allocations have changed, so we need to change the amounts applied to the rate rider.
Yes.
Okay. Another question I had is, how would this, you I think described it briefly earlier, but if you could just walk me through how such a PPA is included in Texas rates, that is to say, in the Texas rate approval. Does the PUCT have an analogous rate rider mechanism through which El Paso Electric would seek a recovery of costs through any allocation to El Paso? You mentioned that there was something called the fuel reconciliation procedure. Is that the only procedure? And I just mentioned that I'm very intimately aware of the cross-border complexities of the Paso del Norte region. So, but I think it's important for us to understand how the two jurisdictions deal with energy that could be coming from a facility that is allocated potentially some percentage in New Mexico and some percentage in Texas.
Okay, so yes, so for Texas, Texas has a fuel factor, much like New Mexico does, where essentially you're passing through the cost of not only fuel for production of power, but also power purchases are passed through the fuel charge in Texas. PPA, the PPAs for renewables or otherwise are, at least in the Texas context, are just purchases of energy, and those are passed through fuel. The reference to the fuel reconciliation is really the proceeding in which the commission looks at all of the costs that you're passing through fuel in Texas and essentially approves of them and says, yes, that that fuel, that energy purchase that you're making from the Santa Teresa facility can be included. You can sort of continue to include it in the fuel rider, and at that point, that amounts to approval for the facility by Texas. The Buena Vista facility that we've talked about previously is a good example. Buena Vista is one part of Buena Vista is a solar facility that serves both Texas and New Mexico. In New Mexico, the cost of Buena Vista are recovered through the FPPCAC. In Texas, the cost of Buena Vista are recovered through the fuel rider. So same thing. Texas does not have a separate cost recovery mechanism for renewables. It's all just, it's all resources recovered through the fuel factor. At least the variable cost resources and purchase power.
I see, and that goes through a rate making process that's separate from New Mexico's RPS rate rider process. Now, a follow-up. Well, just for the record, I didn't hear you. Did you say did you say to my question?
I'm sorry.
Yes. So I asked, and that goes through a rate making process that's separate from New Mexico's RPS rate rider process.
Are you referring to Texas?
Yes.
Texas? Yeah.
Yes. Okay. I just for the record, I wanted to have it heard by the court reporter. Now, what is the El Paso Electric has asked for variances from prior renewable portfolio requirements. Are you familiar with what years you've asked for variances to date?
So specifically, since we talked about the 530 variance, I believe we request that every time, at least with respect and in the proceedings where we've had an RPS cost rider. We have previously, in the history of RPS for El Paso in New Mexico, requested some variances going back into the years prior to REA changes in 2019, I believe. And those variances amounted to not meeting the RPS requirements because of constraints through the renewable cost threshold, for example. That's just the one that comes to mind. In 2020, 21, and 22, when the RPS percentage went to 20%, I believe at that time we were requesting variances from meeting the RPS requirements because of the RCT. So under the rule, we were granted those variances for not meeting the 20%.
We're not meeting, I'm sorry.
The 20% RPS requirement.
Now, Mr. Schiestel, just to get to some other questions about the Santa Teresa facility, the risk related to tariffs or the changes from the One Big Beautiful Bill Act, are those all borne by DESRI, or are there any flow-through risk provisions in the contract based on increasing costs or on tariffs or the expiry of any kind of production investment credit or investment credit?
I could hazard a response here, but I really think that, so just so he won't have to correct me, that's a great question for Mr. Villalobos. He not only generally, but very much specifically to Santa Teresa is much more knowledgeable on this than I am.
Okay.
And I know that we are very actively considering this and talking about it. So I'm sure he can respond to your questions on that.
Okay. One other question I had regards the $500,000 or the $500,000 that is being refunded, and that's going through the FPP CAC. Is there a reason why it's going through that method versus another rebate or reallocation to the ratepayers?
Well, I want to make sure we're talking about, if you're talking about the reconciliation amount that I referred to in 2024, where that is through the RPS rider. It's just factored into the RPS rider. So, for example, it's 500,000 subject to checking against Mr. Gonzalez's testimony. I believe it's $500,000 over collection that then is applied to the cost of 2026 expected 2026 costs, which reduces the RPS rider going forward.
I see. Now, just a broader question: is the intention of El Paso Electric to continually rely on the RPS rider to fulfill its renewable portfolio commitments going forward?
There has been discussion in these proceedings in the last couple of years from parties, suggestions by parties that as the percentage of resources, RPS resources increases over time. So we're 40% of energy now has to be supplied by renewable resources. It'll go up to 50 and then 80%. At some point, the recovery of that, the suggestion by parties has been that the recovery of that much money through a rider starts to maybe conflict with the idea of a rider. And in thinking about that, I don't know that I disagree. I think that on some level it becomes your primary fuel source, and there's no reason why it couldn't be recovered through the FPP CAC. We haven't made any kind of really evaluation or intention to propose any change to that. But I've got to say that I expect in the future that we'll need to address that, really address that question. As I think I said previously, RPS costs were originally recovered to the RPS rider. Some RPS energy is still recovered through the RPS rider, or referred to Buena Vista, the system resource that just goes through the RPS rider. So there's it makes a certain amount of sense as we go forward with RPS and we increase the amount of purchases that we're making there. But I'll just leave it at that. I have thought about it, and I don't find those suggestions ridiculous. I think that it starts to make sense as you go forward. Maybe bring it all back together.
Yes, I wanted to ask also is if you ever foresee any costs associated with the purchase power agreement from the Santa Teresa facility being rolled into a traditional rate case, or if you will see, or if the company sees them as always being associated with the cost under the rate rider.
I think as long as the rider exists, I think it's appropriate that they be recovered under the rider. If you were hypothetically faced with a circumstance where you no longer had cost recovery on the rider, and you instead had to reflect those costs in different components, the solar facility costs would logically be recovered through the FPPCAC as power purchases. The battery costs, the capacity associated with battery costs, while we don't have good examples of that right now in New Mexico, could easily be considered, in my mind, a base rate item or a rate item outside of the fuel. In fact, I don't think you can even include them in FPPCAC. And so I could see that as a base rate item, primarily because the costs don't change for a battery purchase. The cost associated with the solar energy purchases changes from year to year because the output of the facility changes. But at least the way the battery contracts are structured, essentially the rate doesn't change and the capacity doesn't change, and so the cost is substantially fixed.
Thank you. Now, maybe a final question. What contingencies or preparations has El Paso Electric made in the event that the Santa Teresa facility, for some reason, cannot be completed or come to fruition?
You're going to give me nightmares, but we've had to deal with that. Obviously, we've been dealing with that, for the last couple of years. The expected online dates, even to go so far as have a facility just be canceled. The position, I think, that where we have improved is because we have this expectation, or at least the possibility of increasing load over time, is that we're accelerating our procurement practice, at least with respect to, we know what's out there. If you're doing RFPs frequently enough, you always have this stock of resources that potentially you can go to and say, okay, how quickly can I get this built? And so there are more alternatives now for us. If we had to pivot, for example, away from Santa Teresa, I think we could do it a lot better and faster than we have in the past.
I see. Well, Mr. Schiestel, those are all my questions. I believe Ms. Barrett, Hearing Examiner Barrett, may have some questions. But I just want to really thank you for taking all the time and for your patience and professionalism. And the questions I'm asking are really just to better understand the application, but also to better understand the position of EPE, and to make sure that the commission has a strong grounding in what you and your company are dealing with, so that we can have the best outcome for New Mexico ratepayers. Thank you.
Thank you. I appreciate that. Thank you.
Mr. Schietzel, are you okay to keep going, or do you feel like you could use a short break?
No, I'm fine.
Okay. Nice to see you. We knew each other in a past life. I just have a few questions. My questions are specifically mostly tailored to the battery energy storage system, which is something that I have a particular interest in. My first question is actually not referring to your testimony, but to the application itself. If you could turn to page 5 of the application and paragraph 14.
Hearing Examiner Barrett, I'm not sure that he has the application in his packet. Do you?
I do. I just didn't.
Okay.
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 And this could be answered without specific reference to the paragraph as well, but if you do have it.
I do have it.
All right. In paragraph 14, EP is saying that they're proposing to purchase and include 50 megawatts of the battery energy storage component of the project in EP's RPS portfolio. My question is, can you explain to me just in broad strokes how the battery contributes to RECs? How does the battery contribute to the RECs that are collected under the RPS rider?
So, so the RECs that we can, the energy that we can, and RECs that we can count towards RPS are a function of how much renewable energy is delivered to our New Mexico customers. So one of the aspects of a solar facility is that there is potential for curtailment of those facilities when too much energy is being provided to the system. And so what a battery can allow you to do, among other things, is to reduce the amount of curtailments that you might otherwise have associated with the facility, because you have the option then, rather than curtail the output of the facility, to store the output of the facility and then export it later when you do need the energy. And so that's the in my mind, at least with respect to its benefit to the RPS, is that its ability to reduce or to increase the amount from a facility that can be counted towards RPS. Does that make sense?
It does. So the battery storage facility itself is a capacity resource. It's not or it's there for storage capacity. It's not producing any electricity, but I'm just trying to make sure I understand your testimony, but the benefit to it is that it allows for more production from the solar facility itself.
More production, but potentially less curtailment. So certainly the battery component of the facility provides another benefit, and that is that it can, as I described previously, it can move energy to more beneficial times. So for example, if the solar facility is producing renewable energy for RPS purposes at a time when you really don't need that energy, from a system perspective for customers, it's a lower use periods. You can store it in the battery and then export it to the system. It's still renewable energy. It's being, so it counts as RPS energy, but it's exported to the system when that energy is actually needed. So battery doesn't increase the output of the solar facility, but it can increase the amount of energy that is actually exported to the facility, or I'm sorry, to the system, because it doesn't have to be curtailed.
Okay, so the RECs they're only being recorded and retired once, and under this scenario, I think that's what I'm getting at, is the solar facility produces this electricity, but it doesn't go onto the system. It goes into the battery during times of curtailment. And correct me if I'm wrong, but the point at which the REC is actually produced and retired is when that energy is dispatched from the battery onto the system, or is it being double counted?
That is correct. It is counted as energy delivered to New Mexico customers and counts for RPS when it's actually exported from the battery onto the system.
Okay. So now I actually am going to ask you just a couple questions about your direct testimony. If you can go ahead and find page 11. And I need to do the same.
Okay.
Specifically lines 1 through 6, where you discuss the percentage of the renewable energy generated from the STP project. Is it correct that when EPA is seeking approval from the PRC to purchase 100% of renewable generation from the STP, they need this because specifically because of the PPA rule and because they need to show the 40% compliance in New Mexico?
That's correct. That's our calculation is with Santa Teresa operating for approximately half of 26, that all of the energy produced over those 6 months would be sufficient, along with all of our other RPS resources, to meet the 40% requirement in 26. And the distinction I've made on that is I don't want to ask for 100% of the facility in 27, for example, necessarily, because then I'll have twice as much production in 27, right? Because I've got a whole 12 months. And so what we're doing is saying, at least in 26, when it's operational, I'll take all the energy for New Mexico for RPS purposes, and then make a decision for 27 when the facility is fully operational for an entire year, how much I need for 27.
That's fair. And if you could go to page 23, back to the battery.
Okay.
Actually, that question, you actually already answered that question when you were explaining the battery, the retirement of the RECs from the batteries already. So I don't need to ask that. So go ahead and skip forward to page 24. On page 24, lines 2 through 4, you state EPA's New Mexico jurisdiction needs additional capacity now and in the future with the increasing probability of adding new large load customers to the system. And my apologies if you're repeating earlier testimony, I just am looking for clarification. What do you mean exactly by the claim that EPA is going to need more capacity in the New Mexico jurisdiction? And how exactly does this relate to the battery component of the Santa Teresa facility?
Certainly. So the battery provides capacity, meaning it can operate in periods when we need that capacity. In other words, when we're capacity constrained or specifically in the peak periods. So that's its role in addition to supplementing the solar facility and for RPS purposes. It also provides capacity, and so we've demonstrated that it's needed currently for retail sales, but the need for capacity is actually growing in the future, assuming that we add new large load customers. I was discussing earlier, let's say, for example, hypothetically, a data center, right, which is going to operate during the peak periods and for which we'll need to be able to provide or increase capacity on the system for that customer.
Okay. And again, I apologize if you've already provided this information, but is there specific data in this application proving these potential future capacity, this increase in need?
With respect to the additional capacity, that is the position of EPE in our forecast is that those things are going to occur, that we will need additional capacity. I can't say that it's an absolute, that I can prove it until I get I won't say that until I actually have the customer in my system. But our expectation is certainly that we're going to need capacity for those customers. From an RPS perspective, I described earlier how those customers actually, again, assuming something like data center customer, is going to put even more pressure on the RPS requirements because there's so much energy associated with that capacity. And energy is the compliance component for RPS purposes. And I talked about trying to get ahead of this and not continually trying to catch up and have to, allocate from other resources and things. And so the goal here is to say, I'm going to anticipate increasing load, and I'm quite confident that we're going to see increasing loads in the future because of these types of customers, is that we need to procure these resources further in advance so that we're prepared when they come. And so that's certainly one of the aspects of Santa Teresa, is that if you look at it from a perspective of how much New Mexico needs today for RPS purposes, that's the amount that we're proposing for 2026. Okay. And I said that I wouldn't expect that to extend into 27 unless my requirements go up. And so that's the request for sort of this flexibility around the Santa Teresa facility, is because I have this uncertainty about my level of load growth going into the future, but an expectation that it's increasing much more than historical, year-to-year growth. then I need to be prepared to bring more RPS resources on more quickly in order to make to meet the compliance requirements for RPS. So that's the notion of being prepared for this additional load.
Okay. And just very briefly, you used the term forecast earlier. What can you just at a very high level explain to me what elements are considered by EPE when you do this forecasting that we're talking about?
Certainly. We have a pretty robust sales forecasting that we do, and it incorporates both sort of what I would call traditional econometric forecasting based on historical growth. In other words, you look at the past 10 years and you say, this is how fast I'm growing year to year, and my expectation for future years, how it extends, sort of the slope of the growth curve in your forecast. And that's driven by a variety of factors, economic factors. Weather, certainly in our service territory, is a big determinant of that expected growth over time. And then another component is layered on top of that is expectations about, and it's sort of, it does fall under economic, I guess, but it is the expectations about additional new load coming into your service territory of an amount that's greater than your historical. So for example, your historical load growth incorporates increases in commercial and industrial customers over time, as long as those stay, as long as they're about the same every year, right? So you've got this slope associated with your load growth over time, which incorporates expectations around industrial customers or commercial customers and residential customers. When you go into a period of time, there are different periods of time. You can go into a period of time, for example, a couple years ago, there was a lot of discussion and conversation, and even some of them really happened about reshoring of manufacturing facilities, for example, where you've got economic factors that are actually impacting your load growth because of things like, because we're on the border with Mexico, and Santa Teresa is a location for this. There you see maybe an influx of manufacturing that is outside of your normal growth, right? And so you would layer that on top of your growth expectations. In this current case, with respect to data centers, it's the same thing. I have nothing in my head in a historical context, and no component in my historical growth for data centers. And so if I just did an econometric analysis of my historical growth, I'm not going to capture that. And so I have to go outside of that. And it is essentially expressed customer interest. And when you get a lot of customers asking about taking service in your service territory, that is an indication that your growth expectations over time need to change. And so what we've been incorporating into our load forecasting has been exactly that. At some level, that expression of a customer interest is real enough that as a prudent utility, you say, I've got to plan, I have to start planning for this. It's not an absolute certainty in many respects. Ultimately, it will be or it won't be, but it does become incumbent upon us at some point to say, okay, some of this is real and is actually going to happen. And so that's really what this reference is in my testimony with respect to new large load customers in the future.
Okay, thank you. That was actually very helpful. I had a couple of other questions, but I actually think that you addressed them in the process of answering the other ones. So thank you for your patience, and nice speaking with you.
Thank you, hearing examiner Barrett. Well, it's 11:34. Ms. Lynch is back in the hearing. Ms. Lynch, I don't know if you were here when we came back from our 10:30 recess and previewed a break around 11:45 just to continue with our hour and 15-minute cadence. Do you have questions for Mr. Schiestel? And If you do, we can proceed until around 11:45 and then pick up after lunch. But I just wanted to check with you first to see if you had any questions for the witness.
Hearing examiner, I do have a couple of questions based upon the questions that you and hearing examiner Barrett had of Mr. Schiestel.
Okay, great. Well, let's go ahead and proceed then and try to get as much out of our time as possible and make the most efficient use. And then we'll be ready for a well-deserved lunch break, I think. So go ahead, Ms. Lynch.
Okay, thank you. Mr. Schiestel, many of the questions that I have, which are limited in scope, could help us better understand the use of the battery storage facility, especially as it's being proposed here. Are there opportunities for the battery to respond when EPE's load may be at peak?
Yes.
Would the use of the energy generated in the battery be equivalent or less when compared to the use of, say, a peaker plant, a natural gas peaker plant?
I'm not sure I follow your question exactly. I would say, generally speaking, capacity supplied by the battery to the system is not different than capacity provided to the system from another resource.
Does it cost less to provide the capacity from the battery than it may cost when the same capacity is provided from a natural gas peaker plant?
I think thinking purely from the perspective of the cost of the capacity, I think of them as similar in the sense that they are essentially a sunk cost, and that is you're paying for the battery on a capacity basis, and you don't really incur a cost when it actually supplies energy from that stored capacity. That the capacity costs are essentially fixed, which is also the case for example, a natural gas facility. The cost of capacity from that facility is essentially fixed. You've purchased it already. And the variable cost, at least with respect to a gas facility, is really the fuel necessary to produce the energy. You could see a battery as having a fuel cost, meaning it's the cost associated with the energy the variable cost of the energy that you've stored in the battery. So from that perspective, comparing a battery as a capacity resource to a natural gas facility as a capacity resource is really the cost of the sunk cost, the comparison of the sunk cost. What's the total capital cost of the battery? What's the total capital cost of the gas facility?
What about the operational costs? Do those differ significantly?
Meaning specifically just sort of day-to-day operations with respect to the facilities?
Yes, the comparison of the natural gas to the battery.
I don't feel like I can answer that question really. I mean, I think there are certainly operational costs for both. If you separate out separate the fuel as a variable cost and focus purely on the sort of regular operational cost of the facility. I don't think I have a good answer for sort of a comparative basis.
Okay. And this next set of questions mostly deals with the potential load growth that EPE is projecting may come online. For these facilities, when you say there's significant load growth, what do you mean? What does that can you quantify that amount?
Sure. I gave the example of a potential New Mexico facility, at least at its initial phases of 80 megawatts, 80 megawatts. Well, that's more than 10% of our total New Mexico capacity right now. It's 4 or 5 times larger than our largest New Mexico customer. So that's what I mean when I say significant. And that's, in my mind, and what we're seeing in sort of in terms of customer interest is on the low side. The data center customer that we have an opportunity for in El Paso, in Texas, is 200 megawatts. And so you're talking about very large customers. It is not unusual today for data center facilities to be, 500 megawatts to even a gigawatt, so 1,000 megawatts. So these are unbelievably large load customers, well outside of anything, even for a lot of utilities, even with industrial load, well outside the size of a single customer historically.
For these facilities or the, customers, do they always require the utility to supply the energy, or I guess that would be in front of the meter, or do these customers have the potential to generate their own energy?
Yes, I think that it's not that unusual or different than any other industrial customer. I mean, there are even residential customers produce their own energy, right? And rooftop solar. So my answer is yes, they have the ability to provide their own power. Now, when we start to talk about customers this large, you're talking about a pretty significant behind the meter generation facility, but it's certainly possible. And it does happen, to my knowledge, in other locations, it has happened. And it wouldn't surprise me in our service territory. So yes, there is that possibility.
Are there benefits to the utility for the utility to provide the needed load or the needed capacity? And then reversely, would there be benefits to the AI data center customer if they supply their own capacity?
Mr. Hearing Examiner, I apologize. I've given pretty broad latitude on this questioning, but we're getting so far afield of what's actually at issue in this case that I have to object is kind of the speculation of how EPE will serve a hypothetical load by a hypothetical customer in a future plan is really not relevant to the case presented here. So I object as kind of getting way outside the scope of the hearing.
I'm going to maybe find a middle ground here. I'm going to overrule the objection only to the extent, Ms. Lynch, that you may have some more concrete and concrete examples to provide or use. And the reason I want to allow some of this questioning is because the purpose of the facility is to serve presumably New Mexico customers. And I want to just have a better understanding of what Thinking El Paso Electric has done with respect to maybe load coming on, but not needing so much energy. So Ms. Lynch, proceed with your question, but if you can make it as concrete as possible and as unspeculative as possible. Thank you.
Well, I think speculation in this realm is a useful term to hold in our minds. I do think that this is completely relevant to the Renewable Energy Act because how we answer this question, whether our utilities are providing the renewable energy or energy to these facilities, or whether these facilities, which are massive in scope, as Mr. Schistel provided, has a direct impact upon the state in achieving its renewable energy goals. And so in this capacity, as we consider the Renewable Energy Act and its application to procurement of resources, how is EPE thinking about achieving the Renewable Energy Act RPS specific goals in meeting these potential needs of New Mexico's customers? I mean, this is a here and now problem, as you've made clear. That's my question.
Mr. Hearing Examiner, I apologize, and I'm not going to continue interrupting the examination, but I will renew and state my objection for the record that I'm not clear what Ms. Lynch is talking about. I think Mr. Schusel has broadly stated that there will be load growth in the future attributed to large customers and data center. However, the projections that are presented in this case don't reflect that. And so when Ms. Lynch is asking, how does EPE plan to serve that load, I will state that that's speculation down the line, and we have not presented a plan to serve that load because we don't know precisely what that load is. That may be something that's currently being addressed in the ongoing IRP proceeding, but it's outside the scope of this hearing.
Well, thank you. Firstly, I would say there's never a need to apologize for a legitimate concern or objection raised in this hearing. So feel free always to express yourself as needed. I would also say that I'm going to sustain this objection, Ms. Lynch, only to really find questions that are of a granular and pragmatic nature related to the application. So I think maybe it's a good time also to break for lunch, and we can continue with your questions afterwards, Ms. Lynch. This is not to say that no questions can be asked. That's not my goal here. But if we can find as concrete as possible of questions related to the application, I think that would help us in our inquiry. So we'll break now for lunch. We'll come back at 1 o'clock. But before we all break, I just want to give a preview. I'd like to not only have a good use of time and an efficient hearing, but also have the parties see a little bit where we're going to go. So after lunch, we'll continue with Ms. Lynch cross-examination. And then after that, I believe El Paso Electric will have the opportunity to redirect. And then after that point, we can continue with the El Paso Electric witnesses and the cross-examining schedule that we've set forward. So unless any party has something they really want to discuss at this point, we can break. Is there any objection to having a lunch break now? Anything to discuss? Okay, great. No objection. We are off the record until 1 p.m. Santa Fe time, Mountain Standard Time. And thank you, everybody. I'll see you soon.
Thank you.
I think no, it's like, and I'm sitting there thinking, okay,
Good afternoon, everybody. It is 1 o'clock, and we are back in session and on the record. Thank you, everybody, for this morning's proceedings. I believe we were just in the middle of Ms. Lynch cross-examination of witness Mr. Schisto. Maybe they are getting their audio and video set up. It looks like they're coming online now. Great. Hi, Mr. Schisto. Thank you.
Hey, hello.
Okay, Ms. Lynch, would you like to proceed with your cross-exam?
Yes, I just have a couple of questions. I'll leave the AI data center topic in the realm of speculation for now. Mr. Schistel, I was wondering about the Santa Teresa facility specifically. EPE is signing a PPA for the use of the energy that will be produced by that facility. And all of that energy will go to New Mexico within this year, correct?
That's our proposal here, yes.
And in the next year, will that PPA apply to New Mexico only or to New Mexico and Texas?
That's the determination we haven't made yet for 27. As I said, there's enough uncertainty around 27, at least from a RPS perspective. In other words, energy. The capacity, the battery piece of Santa that we've proposed in 26, I would characterize as permanent. I don't expect that to change. I need it today to serve capacity as it's irrespective of future load growth. The battery portion I need today. And I would say that approval of that 50 megawatts will, that 50 megawatts will always be used to serve New Mexico. I won't propose to change it. But the energy portion is the one where we were making the case for flexibility, which was I'm asking for what amounts to half of the facility for New Mexico. I'm doing that in 26 because it's only going to be available half of the year. I take all the energy, but it is effectively half of the energy that facility can produce in a year. I'm saying I need in 26. I don't know what that number is for 27 for a variety of reasons. It may very well be that the amount of energy that we get in 26 is sufficient for 27. And so then the proposal at that point in 2027, then under that scenario, would be I want 50% of the energy from the facility for New Mexico, and the rest will be for Texas. That's the variable that we want to try to keep open. And as I said to the hearing examiner, traditionally, when we said, okay, I want this for RPS purposes, it's the whole facility and it gets approved and then we're done, right? We're not talking anymore about how much goes to New Mexico for RPS purposes. It's just all of it. But with Santa Teresa, it's a little different. And so that's where we're trying to maintain a little bit of flexibility before we make a permanent allocation of the facility between jurisdictions.
So if this PPA were to be approved, would there be necessary action for EPE to take if it wanted to apply the other 50% of the capacity to New Mexico's customers?
The 50% of the energy of the solar facility?
The additional.
Sorry. So I would say yes. So what we're requesting authorization for in the 26 plan year is the amount of energy produced by the facility when it's operational in 26. We have every expectation that we'll make a proposal for 27 for this facility. Now, I would consider approval for in this case approval of this would be, okay, we approve the PPA and the pricing and things like that. What we're really talking about is how much of this facility is going to New Mexico. And so we would be making a proposal for the 27 plan year of how much then of that facility we want for New Mexico.
Okay, I understand. I appreciate your time. I'm done with my questions. Thank you, EPE lawyers, for your congeniality, and thank you so much, Mr. Schiestel, for your time and providing the insight on these follow-up questions.
My pleasure. Thank you.
Thank you, Ms. Lynch. Thank you, Mr. Schiestel. Now, just before we proceed to any redirect, we have another colleague here representing the commission, the commissioners. Her name is Agata Malik, and she has some questions for Mr. Schiestel as we wrap up the cross-examination. Ms. Malik, are you there?
Good afternoon, everyone. Thank you. Yes, I am.
Mr. Hearing Examiner, I apologize. Before we proceed, can we just get clarification? I thought Ms. Malik is typically a witness. I wasn't aware that she's an attorney.
Yes, I believe in a prior life, Ms. Malik was a witness with the utility division here, but she now exercises a role representing the commissioners here on the advisory side. So she'll be asking questions basically on behalf of the commissioners.
Okay, I apologize. This is like a very odd process to me. I've never seen, typically there's like staff counsel and then the commissioners. So this is new territory for me.
No need to apologize. We're very, it's important to hear and take all considerations and thoughts. Ms. Malik, would you like to proceed?
Absolutely. Thank you, Mr. Hearing Examiner. Good afternoon. Just a few short questions to follow up. If I could direct you, please, to page 21 of your testimony. You discussed the liquidated damages for the Hecate project. Can you please explain why EP chose to credit the liquidated damage through the FPP CAC, not the RPS rider?
Certainly. Can I just, you said what page? I'm sorry?
Page 21, I believe.
The top of 21. Got it. Certainly, there are two reasons. First, providing the liquidated damages to customers through the FPPCA as a credit into the FPPCAC allowed us to begin immediately. I'll say immediately, even though it took a while until we finalized the termination contracts and everything, but it allowed us to start providing that to customers a lot sooner than had we done it through the RPS rider. So processing that money through the FPPCAC where we can do it immediately. That's first. Whereas with the RPS rider, it wouldn't have started until the first of next year, which is when the rider in this case will become effective. So we get a good 9 months. I believe we started a couple months ago of that return, and this is over a 2-year period of that, not return of that money, but the provision of that liquidated damages to customers through the FPPCAC. The other issue is reconciliation, and so the FPPCAC is set up. The mechanism itself is designed to, if you are attempting to put in, say, credits to customers through the fuel, the mechanism itself, its balancing account mechanism, is basically ensures that you provide the total amount back to customers, right? You don't know exactly how to get it an amount back to customers because it varies with the amount of sales every month. So if you're trying, for example, to say, I'm going to credit customers $15 million, I can estimate what that credit should be monthly, but I can't guarantee I get it back monthly because I won't know how much retail sales I have. So the mechanism itself, because it has a balancing account, ensures that you ultimately, the $15 million is credited to customers. We have, conversely, in the reconciliation for the RPS rider, we have historically had a lot of complications around that process. It's not as it isn't a monthly process, obviously, as I indicated earlier to the hearing examiner. It's lagged by 2 years. It's just not as, I'll just say it's not as efficient a mechanism as we have in the FPPCAC. So that was our thinking. Start it quicker and really use a mechanism that's designed to do it, and to ensure that if the goal is to credit New Mexico customers $15 million, it actually happens. The mechanism itself makes sure is that you get the whole $15 million credited.
Thank you. Can I just restate to make sure that I've understood what you've explained? You've indicated that it allows the credit to be returned to customers more expeditiously, in this instance, 9 months earlier or sooner than going through the RPS rider, excuse me. Is that correct? What I also heard was because you're able to do a monthly reconciliation using the FCCAC, the amount being returned to customers, if you will, is proportionate or reflected in their usage of resources monthly. Is that correct? Great. Thank you very much. And I'm sorry, I'm having trouble hearing you.
No trouble hearing you too. I don't know if
it may be the internet connection in our building. I apologize for that. I think we have a concurrently running meeting, so that may be using some of our resources. Thank you for that explanation. In terms of the project that's being proposed to be brought online, the STP project, when do you expect that project to come into service?
I could look here. I believe it's the middle of next year, thereabouts, May, I think, May to June of next year. Mr. Villalobos could tell you exactly what the COD is. I don't have it in front of me, and I don't know that I have it in my testimony.
Would it be fair to say that it's an estimate that it will come online middle of 2026?
That's the contractual. The date I'm trying to give you is the contractual COD. So it is firm in the sense that that DESRI could incur penalties if they miss that COD under the PPA. So it's a pretty solid date, although we've missed solid dates before. But yes, it is. That's the projected date for completion, testing, and then ultimately commercial operation.
Thank you. What is the impact to ratepayers if a project is delayed or does not come into service?
Well, it depends. So a project, just taking Santa Teresa, for example, not coming online at the time expected obviously impacts us in terms of RPS compliance. The impact to the customer is essentially what I was describing, I think, with John, in terms of, or perhaps the hearing examiner, in terms of the trade-off between the renewable resource and the price of that resource and the competing resource, which is just whatever the system's going to provide. So to the extent the Santa Teresa is delayed a month, then that's one more month of system energy that's supplied to the customers, and the costs are recovered to the FPPCAC. And the effect of that is really a function of what the price differentials are. If you want to, you can look at it that way. Obviously, the other effect is the renewable energy that's not supplied. So that's what I would say the impacts are, delays.
An additional follow-up for you on that, just to make sure I understand the kind of pricing mechanism. So in the event that the project is delayed by a month, let's say, for that month, the customer would be billed for the cost of whatever other energy is needed to meet that customer's demand. Would they also be paying the proportion RPS rider cost, or is that somehow reduced or offset?
Well, the cost passed through the RPS is only if the facility is providing that energy. So our RPS for 2026 will be designed around an assumption, and that is the assumption that the facility starts operating in the middle of the year, right? And so we estimate, as I described earlier, we estimate the total cost for the year, and we design a rider around that. So from that perspective, you could have a difference between the cost you expected and the cost that were actually incurred because of a delay. And then the reconciliation of that year in 26, when we get to say 2027 and 2028, and we're reconciling 2026, there's where you would capture that difference. If you over recovered or under recovered because the expected resource came online later than expected, or it didn't produce as much as you expected, either one. So that's captured in reconciliation.
And thank you. And how frequently does that reconciliation occur? Is that done annually?
It is done annually in the RPS proceeding. Each year, for this year, for example, the year that is reconciled is 2 years prior.
Thank you.
It's performed every year.
Thank you very much. I know earlier today in testimony, you mentioned that EPE is looking forward in terms of systems planning and anticipating an increase in the RPS requirement to 50% in the future. With that in mind, can you help me understand why perhaps a larger project wasn't selected, sort of with the view of anticipating future system needs, or also filling some prior year deficiencies?
That's certainly a consideration, and something that we thought about and discussed. That is this aspect of oversizing, say, a facility from either from a PPA perspective or otherwise, but getting more than you need in the near term, so that you have that capacity when you do need it a couple of years down the road. I will say that from an annual load increase perspective, that's built into the assumptions. So is the changes. So in 2035, when we have to go to 10, an additional 10%, that's a big jump. Not as big as the 20 to 40, but it's another big jump. I do see us today trying to plan towards that. In this particular case, I think that what we were at least at the time we're looking at is just replacing the facility that we had expected to have already. There's a cost, obviously, or there could be a cost, obviously, to getting too far ahead on your RPS, even though the statute, I believe, contemplates rewarding you for going faster, but you are impacting your customers potentially through the renewable resources that you're procuring. And so we try to find the balance between, okay, I want to be ready when the time comes, but I don't want to be too ready and too far in the future and end up my customers paying more in advance than they might otherwise if I just timed it a little better. But that's tricky and it's complicated by instances like we've had in the past, and that I don't think will repeat themselves, but that delays facilities, so it kind of messes up your plan. But it's a really good question, because that's exactly what we think about. It's okay, how big do we need to go here, and oversize? But we have been, EPE at least has been catching up for so long that we've really had to focus on that. Let's just get current, and then we can start thinking about future.
Thank you. Sort of a follow-up question to that. You mentioned the need and desire to get current. As I understand, there are some deficiencies for prior years. Could you tell me a little bit more about the plan to address those?
Sure. So I think I mentioned 2020, 21, and 22, where we had variances that basically allowed, I don't know if it was a variant. Well, we had a commission order saying you can retroactively comply with your 20% requirements in those years, meaning produce more in the future than you need, and then retroactively apply it to those years. We're still under that order, right? We still have the requirement in my mind to retroactively comply with those amounts. And so our plan, until we had these issues with some of the other facilities, the termination of the one contract, for example, our plan had been, we were building in an oversupply of RECs in the future so that we could do that retroactive compliance. And so I would say I still have every intention of doing that pursuant to the order. So it goes to one more, to your suggestion that perhaps you look further ahead and you have more than you need. Well, that's what we're going to have to do in order to retroactive compliance. But as I said, just getting caught up and then having to meet the 40% requirement, which I think is a great accomplishment under the circumstances, and then have enough ultimately to do retroactive compliance. The first thing in my mind, the first thing to do is comply. The second with the current year, and then it's to cover those years. So when we get to the point where we're having any oversupply at all, and we're fairly certain of the path forward, I think that's the time to do the retroactive compliance.
Thank you. You mentioned also cost to ratepayers of potentially pursuing oversupply. Are there any other constraints or considerations that might impact a decision to bring on a smaller versus a larger facility?
Well, yes, absolutely. And oversupply of energy in the early part of the day and middle of the day, as happens in California and happens in other areas with renewables, because solar specifically produces when it produces. It can be the case that you have an oversupply of energy on your system in that part of the day. Now, battery is a solution for that, and curtailment is a solution for that, but those are expensive. And so oversupplying, going too far on the oversupply side, if it puts you in the position then of having to curtail that energy anyway, really, I think works against you. And so, and has a cost. And so there is that consideration as well. Obviously it's rare, at least in my experience now, to see solar that's not paired with battery storage and as a proposed resource. You see standalone battery, but I think just like I say, in my experience, you're seeing less and less standalone solar, and that's why, because you're trying to maximize your ability to get that solar actually on the system and not have to curtail it, or even in a negative energy price situation, have to pay people to take your power.
Thank you. Thank you for that explanation. One last question. I know in prior years, when EP was seeking approval of a reallocation, there was an associated percentage and a cost. It looks like in this application, we have that for the initial 2026 year with the 100% solar and I think it was 50 megawatt of the battery storage going to serve New Mexico customers. But EPE is asking for flexibility for future years. Do we have any cost or price certainty if the allocation is changed?
I think if I follow your question, the price per megawatt hour for the solar facility won't change from 26 to 27. It won't change as a function of how much is being allocated to New Mexico. It is a unit price that applies to however much is being allocated. So certainly the cost would go up if you're allocating more, the total cost, but the unit cost would be the same. It's fixed under the PPA.
So the price per megawatt hour would remain constant regardless of the allocation percentage.
That's correct for the solar facility. That's correct.
Would that also apply to the battery storage component?
Exactly the same. That is a contractual price. Now, again, the total cost, if you say were to expand the amount that you wanted to allocate for the battery to New Mexico, could go up, but the price per kW month, which I think is how it's priced, would stay the same.
Thank you. In your experience, do you anticipate that EPE's reallocation will functionally be expected to lower costs to New Mexico ratepayers, or is it possible that rates might increase as a result of a reallocation?
Are you asking about 2027, the difference between 26 and 27?
Or future years, because I believe it's somewhat open-ended in the application.
Yeah, I think that goes more toward what I was describing earlier about as you bring on more of dedicated resources for RPS purposes, you're purchasing less energy supplied by the system, let's say from system or non-renewable sources, and the impact to customers between those two choices really comes down to the price between the two. And so the question of whether or not, not that many years ago we were saying, okay, prices for renewables are going to continue to decline, solar is going to continue to decline, and at some point it's actually going to be the cost-effective resource anyway. I think we're about there or close. Maybe it's slowed down in terms of, and certainly, policy decisions, federal policy can change that. But I certainly think renewables are on a trajectory to be competitive with any other resource and maybe even cheaper. And so the long-term benefit of the RPS in my mind for New Mexico, or I should say the benefit of RPS in New Mexico beyond a clean portfolio, more renewables it really is about the long-term trajectory, because you're fixing prices for power through contracts, and less and less of your purchases are subject to variable costs like natural gas. And so you're hedging against cost increases in the future while you're also increasing your amounts of renewables and all the environmental and everything else benefits of doing that.
Thank you. So just to, again, make sure I've understood correctly, as the percentage of renewables on the system increases, the expectation is there would be more price certainty, because that would be tied to prices agreed through PPAs and other contract mechanisms. Is that accurate?
I'm sorry, what was your answer?
Yes.
Thank you very much for the opportunity to ask questions and for your time today. I have no further questions.
Thank you.
Thank you.
Thank you, Ms. Malik. I believe every party has had an opportunity to conduct cross-examination of the witness. At this point, I think we're ready to proceed to any redirect from El Paso Electric. Ms. Olson?
Thank you, hearing examiner. I do just have some very brief redirect for Mr. Schiestel. Mr. Schuessel, I want to take you back to the questions you were asked about cost recovery. And I believe the hearing examiner was asking you, hypothetically, what would happen if the commission approved EPE's Renewable Energy Act plan for 2026, which does include the new Santa Teresa resource, but excluded some of the costs from recovery under the renewable portfolio, or what is it, RPS cost rider. And so I just want to walk you through that again, because I think there was some maybe confusion in the testimony on that. You've been EPE's regulatory witness in this proceeding for a number of years, correct? Yeah. And so is it fair to assume that you have a general non-lawyer understanding of the statutes and regulations regarding cost recovery?
Yes.
Is it your understanding that the Renewable Energy Act and the Commission's rule implementing that act provide for cost recovery of the renewable portfolio costs?
Correct. If the commission approves a resource in the RPS proceeding, that EPE would be provided cost recovery for, yes.
And recognizing you don't have the actual statutory or regulatory language in front of you, all represent that the statute provides a public utility that procures or generates renewable energy shall recover through the rate making process the reasonable cost of complying with the renewable portfolio standard. And I want to ask you about that term rate making process. Is it your understanding that the commission in prior proceedings has approved EPE's recovery of the renewable portfolio standard costs through the RPS cost rider?
Yes, recently, yes, is the initiation of the rider.
And we do also have Mr. Gonzalez testifying, so if any of these questions I ask are better served for him, let me know. But I believe he testifies that the EPE's RPS cost rider was approved in 2018. Does that sound right to you?
Yes.
And prior to that, how did EPE recover the cost for compliance with the RPS?
I think I said earlier, substantially through the fuel and purchase power cost allocation clause, but also through base rates. So there was some portion of costs associated with RPS compliance that was essentially approved in the RPS applications, but cost recovery was deferred until they could be placed into base rates with carrying charges. So, for example, we were just remembering that there was a wind contract at one point that was not processed for cost recovery purposes through the FPPCAC, but instead was amortized in base rates, so it was actually cost recovery. Cost recovery was actually through base rates after a rate case.
And Mr. Schuessel, if the commission were to approve the renewable portfolio standard without approving recovery of costs, what would EPE's plan for the Santa Teresa resource be?
So yes, I don't know. I don't think that I understood the question earlier in that way. Our expectation would be, if with approval of use of the battery for RPS purposes approved in this proceeding, but that the battery was not included in the RPS rider for cost recovery, it would be to defer recovery of those, record the costs associated with those with the use of the battery under the contract, under the PPA, and then propose recovery for those costs later in the more than likely in our next rate case.
If the commission were to deny cost recovery for the resource period, would EPE still use that resource for New Mexico?
Well, I guess I think of that as essentially the commission not approving the resource, that is the battery portion of the resource. And you know, just like any other denial of a proposal for resources, I would know it wouldn't be used to serve New Mexico, and we wouldn't have cost recovery for it for New Mexico. That an analogy it wasn't in the RPS proceeding, but we had an LTPPA, for example, for battery storage that was denied. And that to me basically says no to the resource and no to cost recovery.
And is the same true for the energy portion? If the commission were not to approve a mechanism for recovering costs of the energy from that resource, would EPE continue to use that resource for New Mexico?
No, as I said, I would interpret that as a rejection of the resource. If you can't recover the costs associated with providing the service, then the service proposal is denied.
Thank you. Those are all the questions I have.
Thank you, Ms. Olson. I believe that we have finished the direct, redirect, and cross-examination of this witness. If there's no other objection to excusing and thanking Mr. Schiestel for his time, we can go ahead and do that and move to your next witness, Ms. Olson, for El Paso Electric.
Thank you, Mr. Hearing Examiner. I believe we'll be going to Mr. Wayne Oliver next, but I just want to confirm, is he still in the waiting room?
He was, yes, as of a few moments ago. Yes, he's still there.
Okay, if you want to admit him, then
Sure.
we can proceed with him.
Just before I do that, I just want to say thanks again, Mr. Schiestel. It's we really appreciate your time and your today that you dedicated to this hearing. Thank you so much.
My pleasure. Thank you.
Thank you.
Have a nice day.
Okay, I'm going to admit Mr. Oliver at this moment. Mr. Oliver, can you hear us? Mr. Oliver?
Oh, yes, I can hear you now. Yes.
Hi. Yes. Would you be able to turn your camera on?
Okay.
Excellent. Thank you so much. Thank you for being here with us, Mr. Oliver. Your attorney, Ms. Olson, I believe, will conduct a direct examination, but first we need to swear you in.
Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Thank you. Go ahead, Ms. Olson.
Thank you. Good afternoon, Mr. Oliver.
Good afternoon, Ms. Olson.
Can you please state and spell your name for the record?
Yes, my name is Wayne Oliver, Wayne Oliver.
And what is your current profession?
I'm CEO of Merrimack Energy Group, Inc.
Mr. Oliver, do you have before you what's been marked as EPE exhibit number 4?
Just one second. Yes, I do.
And do you recognize that as the pre-filed direct testimony you prepared for this proceeding?
Yes, it is.
Was that direct testimony drafted by you or under your direct supervision?
Yes.
And do you have any corrections to your direct testimony?
No, I do not.
Is the direct testimony that you prepared true and accurate to the best of your knowledge and belief?
Yes,
And if you were asked these same questions today under oath, would your answers be the same?
yeah, yes,
Mr. Hearing Examiner, El Paso Electric offers EPE exhibit number 4.
Thank you, Ms. Wilson. Are there any objections to the admission of this evidence? It's admitted.
And Mr. Oliver, do you also have before you what's been marked as EPE exhibit number 5?
yes, I do.
And do you recognize this as your pre-filed rebuttal testimony for this proceeding?
Yes,
Was the rebuttal testimony also drafted by you or under your supervision?
yes, it was.
And do you have any corrections to your rebuttal testimony?
I do. I have one correction. And it's, I'm sorry, it's exhibit WJO-R-2.
And Mr. Hearing Examiner, this correction was not marked in the exhibits that we uploaded. Mr. Oliver identified this correction as he was preparing for hearing yesterday. So he can identify the correction, and then I don't know if it would be possible for the court reporter to mark the copy, or I'm happy to circulate a corrected page, whatever would be the easiest.
Yes, I think maybe if you could circulate a corrected copy. Also, maybe just explain the nature of the correction.
Sure. Mr. Oliver, can you please walk us through that correction?
Yes, it's on the exhibit I referenced, it's note number 1. It says for the tag project, that should have been for the Quail Ranch project. And the reason for the error is that I felt that, you know, I revised the table at the last minute, and to put Quail Ranch was the only project that basically had variable charges for both the solar and the storage. So I put that up front, and then put the footnote in, but I didn't change the tag to Quail Ranch. So that was the nature of the error.
And is that the only correction to your testimony?
Yes,
With that correction, is the rebuttal testimony you prepared true and accurate to the best of your knowledge and belief?
yes, it is.
And if you were asked these same questions today, would your answers be the same under oath?
Yes,
Mr. Hearing Examiner, El Paso Electric offers EPE exhibit number 5 as corrected on this stand today.
Are there any objections to the admission of this evidence? Hearing none, I'll admit the testimony. Thank you, Ms. Olson.
That concludes my direct examination. I tender Mr. Oliver for cross-examination and examination by the hearing examiners.
Thank you. So moving ahead with our order of cross-examination, does Danya County have any questions for Mr. Oliver?
Thank you.
I'm sorry.
Mr. Herman, you broke up a little bit.
I don't know what he said.
Not sure either. One more time.
I have no questions, and I will wait my cross-exam changed.
Okay.
Did I come in?
No, okay, all right, thanks.
Did he just say no?
He said no.
Okay.
Mr. Herman, with a yes or no answer, did you say you were waiving your the rest of your questions for Mr. Oliver? Is that what you were trying to say?
Yes.
Okay, so you have no cross-examination for Mr. Oliver. Okay, thank you. Thank you, Mr. Herman. Next, in our order of cross-examination, Ms. Lynch from Coalition for Clean Affordable Energy. Do you have any questions for Mr. Oliver?
No, at this time I don't. Thank you, hearing examiner.
Thank you, Ms. Lynch. I do not have any questions for Mr. Oliver. I'm not sure. I don't believe anyone else does either. So unless there's a redirect, I don't think there's basis for a redirect, but unless there's anything else that El Paso Electric would like to ask Mr. Oliver, I think we can excuse the witness.
Mr. Begacco has a concerned look. Did you have any questions?
My feelings are just hurt because I always get left out. But
I'm sorry, Mr. Begacco. I'm very, very sorry. Please, it's been a hectic week, as you know.
I had one question for him, but I don't think it's necessary anymore. And I thank Mr. Oliver for his participation. Thank you, everybody.
Thank you.
Thank you, Mr. Oliver. Again, my apologies, Mr. Begacco. Been hectic. Okay. Well, thank you, Mr. Oliver. Thank you, Ms. Olson.
Thank you.
Your next witness, Ms. Olson.
Thank you, Mr. Hearing Examiner. EPE would next call Mr. Emmanuel Villalobos.
Okay, let me see if I can. Oh, he's going to come in through your EPE witness link, right?
Yes, hopefully he'll show up in that little box.
Great, thank you.
I'm still coming through loud and clear, right?
Yes.
I didn't know Mr. Herman knew how to speak Klingon. I'm impressed.
I don't know how to spell it.
Is the EPE witness coming on? Oh, there we go.
There we go. Mr. Villalobos, can you hear me?
Hey there. Yes, I can hear you now.
Great to see you. So we'll swear you in first with our court reporter, and then we can proceed with the direct examination. Ms. Gonsalves?
Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God? What was that?
I do.
Thank you.
Yeah, just before we proceed, Mr. Villalobos, sometimes in the El Paso Electric witness room where you are now, there's a slight delay at the beginning of speaking. So sometimes the one-word answers, the yeses or the nos, become a bit inaudible. So I just wanted to alert you to that fact. But otherwise, the sound and the video is of very high quality. But sometimes those brief one or two word answers in the beginning can be a little cut off. So I wanted to mention that.
Thank you. I appreciate it. I'll keep that in mind.
Sure. Go ahead, Ms. Olson.
Thank you. Good afternoon, Mr. Villalobos. Will you please state and spell your name for the record?
My name is Emmanuel Villalobos. You spell my name Emmanuel. Last name Villalobos.
And Mr. Villalobos, what is your current profession?
I am the Director for Market Development and Resource Strategy at El Paso.
Do you have before you what's previously been marked as EPE Exhibit number 3?
Yes, I do.
And do you recognize this document as the direct testimony that you pre-filed in this proceeding?
Yes, it is.
Was that direct testimony drafted by you or under your direct supervision?
Yes, it was.
Do you have any corrections to your direct testimony?
I do. I have one.
And let's go to page 33.
Yes, I'm there.
Can you walk us through that correction?
The correction is for the original amount that's listed. It's in lines 11 and 12, where the original amount of 158 and 73 cents is replaced with 177 and 98 cents.
And can you just explain the basis for that correction?
It was just the conversion from dollars to dollar per megawatt hour to dollars per kW year.
With that correction, is the direct testimony that you prepared true and accurate to the best of your knowledge and belief?
Yes, it is.
And if you were asked these same questions today under oath, would you give the same answers?
Yes. Yes, I would.
Mr. Hearing Examiner, El Paso Electric offers EPE exhibit number 3.
Are there any objections to the admission of this testimony? Hearing none, it will be admitted to the evidentiary record.
Thank you, Mr. Hearing Examiner. That concludes my direct examination of Mr. Villalobos. I would tender him for a further examination.
Thank you, Ms. Olson. Mr. Herman, do you have any questions for this witness?
No, and this is something if it would have been some message in chat.
I'm sorry. I don't know if that was. I didn't understand that.
Okay, well, my
Hearing Examiner Schaefer, I think that Mr. Herman is referring you to the chat, and
yes, I was just
perhaps he could communicate that way, and then you could read it into the record.
That's exactly what I was going to do. Yes, Mr. Herman in his chat says, apologies for my internet connection. The county waives all remaining cross-examination for all remaining witnesses and requests to be excused for the remainder of the hearing. Knowing the consequences of your excusal, the hearing examiner grants your request for excusal. Thank you for being with us, Mr. Herman. Very much appreciated. Thank you. Next on our list is Ms. Lynch.
I have no questions for this witness.
Thank you, Ms. Lynch. Next on our list is Mr. John Bagatko.
Yes, please. Just a few questions for Mr. Villalobos, if you'll permit me.
Of course.
All right. Good afternoon, Mr. Villalobos. It's good to see you again. How have you been?
Good afternoon, Mr. Regato. I've been well. How about yourself?
Fair to Midland, working on getting through this thing and not asking too many dumb questions. So just bear with me. Here we go. I'm going to direct your attention to page 26 of your direct testimony that I think EPE is marked as Exhibit 3. Just let me know when you get to page 26. I'm looking at a few lines up at the top.
I am on page 26.
All right, looking at lines 2 through 5. There at the end of, starting at the end of line 2, you say the final fixed rate of the battery storage capacity will be based off the 90-day average spot price of lithium carbonate in the Shanghai metals market at the time the lithium is delivered to the factory. Is that, did I recite that accurately?
Yes, sir, you did.
I just want to unpack this a little bit because if you can explain, I mean, you talk about being delivered to the factory. You're talking about the manufacturer of the battery itself in its entirety, or is this a subcontractor with a subcomponent? How does this work to your knowledge?
To my knowledge, this is for the lithium that is delivered to the factory for the manufacturer.
And who's the manufacturer? You know.
I do not know who that is. Apologies.
Okay. Do you know who like certifies and determines the delivery date and that it's actually delivered to them and in their hands for purposes of this provision?
I do not know.
Okay. Well, then going to the 90-day average spot price issue and moving to the paragraph below the excerpt I just discussed with you. Lines 6 through 9, there you say, based on historical lithium carbonate pricing over the last 5
I'm sorry,
years.
please slow down just a little bit for me and
Oh,
start
I'm
over.
sorry, I will. Based on historical lithium carbonate pricing over the last 5 years, pricing could range from approximately 1 kilowatt month lower to 50 cents, I guess, per kilowatt month higher. In any event, if the lithium price increase exceeds about 1 kilowatt month, depending on exchange rate, ESA provides that EPE may renegotiate or terminate the agreement. Is that an accurate recitation of your testimony there on page 26, lines 6 through 10?
Yes, it is.
You filed this testimony back on May 1st, 2025, correct?
I believe that is correct, yes.
Right. That can be a short amount of time or a long amount of time, depending on what's going on. But what I'm thinking of specifically are recent developments in terms of things that have been announced with regards to federal policy that affects this sort of undertaking. Has anything that you've seen from the federal government affected or changed the assessment that you provided there on page 26 with regards to pricing and lithium carbonate?
No, sir, not for this facility, no.
Okay. And then going back down to page 26 there on lines 9 through 10, talking about the possibility of renegotiating or terminating the agreement. What's the threshold to renegotiating? Let's say something happens that really just drives the price up astronomically. Do you have a point at which you're just going to say, sorry, Charlie, we're not interested anymore and we're just going to terminate?
I believe, if I remember correctly, that is in the contract, what that ceiling would be. I do not recall off the top of my head what it is, but yes, there is a point at which we can go back to the table and renegotiate or walk away.
I presume that the strong desire on the part of EPE to be compliant with the Renewable Energy Act would factor into final determination at that point. That is whether to renegotiate or just pull the trigger and kill this thing.
I'm sorry, the audio was a little choppy for me there at the beginning. If you wouldn't mind repeating the question.
Sure. I presume then that EPE's understood desire to be compliant with the REA would factor into the analysis at that point if we were to go down the path of this possibility of renegotiating or terminating in the face of exorbitant lithium carbonate prices.
Yes.
Okay. Let's say you go down the path of termination and the battery is just taken out of the equation for purposes of this application and the prospect of being compliant with the REA going forward. What, if you know, would EPE consider in terms of trying to attain compliance at that point under those unfortunate circumstances?
I believe that some of the mechanisms available to the company would be issuing a short-term RFP for the energy and RECs that we would be missing at that point for compliance. I would assume that's the most likely course.
Do you have any familiarity with the applicable timetable that might pertain to a short-term RFP as you just discussed?
Short-term RFPs are usually issued by the marketing department, and those are range from a couple of weeks to I think it's less than a year is what their usual time frame is.
Okay. It's safe to say that EPE would be interested in coming up with such a remedy and working with the commission to fill in the gap, so to speak. Is that a fair presumption on my part?
Absolutely, yes, sir.
Well, other than that, I don't think I have any further questions. I think your testimony and then the attachments to it with a very handy definition section were very useful, and I appreciate your work on this case. Thank you.
That's very kind. Thank you, sir. I appreciate that.
I pass the witness, Mr. Hearing Examiner. Thank you.
Thank you, Mr. Begacco. I do actually have a couple questions, Mr. Villalobos. Thank you again for taking the time to be here with us. And I asked a prior witness about the price of the energy under the PPA and I guess the ESA as well, and was led to believe, and excuse me if I misunderstood the witness, that the price was fixed, and that any risk of cost increase to the facility, including energy storage, battery storage, would be borne by the developer. But as Mr. Begacco has pointed out in your testimony, there seems to be some kind of risk associated with El Paso Electric. That is to say that EPE might bear a cost increase risk based on fluctuations in resource or inputs that are necessary to build this facility. Is that correct?
Yes, yes, it is. That is correct. The lithium carbonate indice, though, is the only mechanism in the contract that would allow for that change in pricing, and those are capped. And the risk of that is minimized because of the facility is already under construction and its immediate COD date in the first half of 2026. So those types of risks, price adjustments and things like that are greatly reduced since the facility is already under construction.
So if I understand you correctly, you're saying that the sole remaining cost risk is the price of the lithium because it has not yet been acquired. Is that correct?
That would be my understanding for the battery portion of it, but I am not aware as to the developer where they are in their procurement process. I do recall some conversations where they had already been procuring the resources, the equipment. So again, I would just assume that that risk is minimal to non-existent at this point.
Okay, so just to follow the logic here in my own mind, the final price of the Santa Teresa facility or the STP, Santa Teresa project, has not been fully determined. Is that correct?
Yeah, I think that's an accurate description of it until the lithium has been delivered, yes.
Okay. Is there a, not to speculate, I'm not asking you to speculate, but is there, no, truly, I'm not. But has EPE considered what range, because you just, for example, mentioned caps in your response to Mr. Begacco. Has EPE considered what the outside increase in cost might be to that facility? That is to say, what the price increases may result, what price may result in the increases due to fluctuations in lithium?
I really wouldn't feel comfortable speculating that right now. I mean, yeah, yes, the company would take into consideration what that dollar amount would be, what that range is. I just don't have it, what it would be for that, that conversation hasn't happened.
Sure, no worries. I guess just to provide detail, and again, not asking, I wasn't asking for you to imagine or just, come up with something, but I was just curious if El Paso Electric had bracketed the cost, for example, done any kind of bracketing cost projections of what the battery storage facility might result in.
Oh, okay. I understand your question better now. Thank you. Not to my knowledge.
Okay. So finally, maybe I'll ask, the fluctuation of the battery storage portion of the project would impact the cost of energy delivered from that battery storage project. Is that correct?
It would impact the price of the capacity, not the price of the energy delivered to the battery. That would be the fixed price from the solar facility.
Okay, okay. Okay, well, thank you, Mr. Villalobos. I don't have any other questions. Ms. Olson, do you have any redirect for Mr. Villalobos?
Thank you, Mr. Hearing Examiner. I do not have any redirect.
Thank you. Well, with that and direct, cross, and redirect concluded, Mr. Villalobos, I thank you for your participation in today's hearing. These are very important issues, and we truly appreciate your time and your professionalism. Thank you.
Oh, thank you very much. I appreciate it.
Thank you. Okay, so moving on, I believe, Ms. Olson, you have one other witness to call. Is that correct?
Yes, that's correct. Our next witness would be Mr. Gonzalez.
Great, thank you.
And I just taking a look quick at the clock. I'm happy to present him, and then we could take a break before cross-examination, or we can keep proceeding. However,
Let's do that. Yeah, let's do that. Let's really try to maximize everyone's time, and that's a good suggestion, Ms. Olson.
okay. I think they're just switching seats in the.
Oh, no worries, no worries, no worries. Good afternoon, Mr. Gonzalez.
Yeah. Is he frozen? No, I think. I need to flip it myself.
Not a good day for audio.
It's the worst.
I think, Mr. Gonzalez, can you hear us? I think you're on mute. I think you're muted. There you go.
Thank you.
Are you there?
Yes.
Excellent. Mr. Gonzalez, welcome to today's hearing. Thank you for being with us. We'll get you sworn in here with our court reporter, and then we can proceed to direct examination. Ms. Gonzalez?
Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Good afternoon, Mr. Gonzalez. Will you please state and spell your name for the record?
Rene Gonzalez, first name Rene, last name Gonzalez.
And what is your current profession?
I'm a supervisor of the Rates Regulatory Department.
Do you have before you what's been marked as EPE exhibit number 6?
Yes, I do.
And do you recognize that as the pre-filed testimony you prepared for this case?
Yes.
And was that testimony prepared by you or under your direct supervision?
Yes, it was.
And do you have any corrections to your direct testimony?
Yes, I do. One minor correction.
And I think it's on page 4, is that correct?
That's correct. Page 4, line 17. A misspelling of the word 7. It was spelled Sevent, and I've just added the H to it.
With that correction, is your direct testimony true and accurate to the best of your knowledge and belief?
Yes, it is.
And if you were asked the same questions today under oath, would you give the same responses?
Yes, I would.
Apologize, I feel like I'm gonna sneeze.
No worries.
Mr. Hearing Examiner, we move to admit EPE exhibit number 6.
Are there any objections? The testimony will be admitted into the record. Thank you.
And that concludes my direct examination of Mr. Gonzalez. I would tender him for examination by the other parties.
I'll just check before we take a break. Do any of the parties, Diana County has waived? Ms. Lynch, do you have any cross-examination for this witness?
I do not.
Thank you, Ms. Lynch. Mr. Bagatko, do you have any cross-examination for this witness?
Mr. Hearing Examiner, no cross-examination for Mr. Gonzalez, but we do thank him for his testimony and participation.
Thank you so much. I don't believe that I've missed any party now that Mr. Herman has been excused. Well, I have no questions for you, Mr. Villalobos. I'll just say before you're excused that we thank you for your time and attention very much and your efforts to appear here today before us. Thank you so much.
Thank you.
Any redirect, Miss? Okay, sorry. Okay, great. Well, let's take a break and we'll reconvene here at 2:26. And then we'll probably wrap up this hearing. Mr. Bagatko, just before we all break, you will be calling Mr. Dunn as a witness. Is that correct?
Mr. Dunn is the only one I have left, and I will call him. And I think he's chomping at the bit and ready to go.
Excellent. Okay, so at 2:27, we'll reconvene. Until then, we're in recess. Thank you so much, everybody. Good afternoon, everybody. It is 2:27. We are back in session and on the record. I believe at this point it's time to turn our attention to our staff witness, Mr. Dunn. Mr. Bagacco, are you ready to proceed?
Yes, please.
Thank you. Ms. Gonsalves, are you ready?
Yes.
Thank you. Okay, I'm going to admit Mr. Christopher, and then we'll swear him in. Mr. Dunn?
Yes, can you hear me?
Yes, thank you. Can you hear us?
Yes, I can.
Great. Well, we'll go ahead and get you sworn in with our court reporter, and then Mr. Bagacco will proceed with his direct examination.
Raise your right hand. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Mr. Hearing Examiner, may I proceed?
Yes, please proceed.
All right, thank you. Mr. Dunn, good afternoon. How are you today?
I'm doing well. Thank you for asking, Mr. Bogatko. How are you?
I'm all right. I hope I'm coming through loud and clear because we've had a few difficulties with our broadband this morning and this afternoon. So,
I'm sorry, what was that? Mr. Dunn, I'm sorry.
I commented, gratefully, I can hear you loud and clear here.
okay. And I will try to go slow for our court reporter who's been fantastic. So, here we go. Mr. Dunn, you prepared some direct testimony in this case, did you not?
I certainly did.
And I trust and hope that you have a copy of it in front of you that has been marked as Staff Exhibit 2 done direct. Do you have that?
Yes, sir, I do.
Would you please take a moment and go through that and make sure that that is an accurate rendition of what you caused to be filed in this case on June 20th, 2025?
Yes, sir. Having briefly reviewed the testimony, I believe it is an accurate rendition of what I caused to be filed on that date.
Okay, and in the run-up to this, we did have a few corrections to this testimony, did we not?
Yes, we do have some corrections. If I could direct attention to Exhibit CED4, page 101, and I will identify the first correction. On Exhibit CED4, page 101, the fifth row of the tables that are listed there incorrectly stated previously kWh/YR, kilowatt hour per year. It has since been corrected in red on Exhibit CED4 to read MWH/YR, megawatt hour per year. That correction applies to Exhibit CED4. I have similar corrections to make to Exhibit CED5, CED6, CED7, and CED8. The corrections are identical to what I had just articulated for CED4. I can walk through each of those if necessary. I apologize for interrupting, but I can walk through each of those individually if necessary, but the correction is the same for each of those exhibits.
How about this? Are those corrections readily identifiable in those exhibits via red line strike throughs and then red line additions clarifying?
Yes, sir, they are.
Okay. So with those corrections established, this is the testimony that you caused to be filed in this case, and this testimony is what you drafted and submitted in support of staff's position in this proceeding, correct?
Yes, sir.
And with those corrections identified, now would you have any other reason to modify your testimony as we see here in Staff Exhibit 2?
No, sir.
And the questions then that we see posed in that pre-filed direct testimony and the answers to the same remain as they are in that, meaning to say that you're not going to change your answers to any of the questions in the pre-filed direct, right?
My answers to those questions would remain the same today. Yes, sir.
All right, thank you for that. I'm sorry, I'm getting a little tongue tied. I think it's been about 30 minutes since I had a cup of coffee, but I would then move for. I'm sorry, did somebody have something to say?
No, go ahead, Mr. Begecko.
Okay, I'd like to admit Mr. Dunn's testimony marked as staff exhibit 2 into the evidentiary record, please.
Are there any objections to the admission of this testimony? No, the testimony will be admitted into the evidentiary record. Thank you, Mr. Begecko.
Thank you for that, Mr. Hearing Examiner. And with that, I would tender Mr. Dunn for any cross-examination by CCAE or other examination by you or the commissioners, perhaps.
Thank you. Ms. Olson, El Paso Electric, do you have any questions for this witness?
Thank you, Mr. Hearing Examiner, and thank you for your testimony, Mr. Dunn. We have no examination questions.
Thank you. Mr. Herman has waived and has been excused. Ms. Lynch, you're next on the list. Do you have any questions for Mr. Dunn?
At this time, I do not have any questions.
Okay. Well, I just have a couple questions. Mr. Dunn, thank you again for taking the time to be here with us today. And I'd like to draw your attention to your testimony on page 20. This is the discussion of the difference in price from the Carne project to the STP or the Santa Teresa project. And in particular, I'm referring to generally the discussion of the original Carne project of $10.99, inflation adjusted of $11.83. And then you compare that with the Santa Teresa project being 9.5% higher. And you say that that's reasonable. So my question really concerns this determination of reasonableness. And is it reasonable just because it's a single digit increase? That is to say, what about that increase makes it reasonable? What would make it unreasonable? What are the criteria or parameters that you used to determine that it was reasonable?
Yeah, thank you, Mr. Hearing Examiner. I believe that that's really a judgment that staff made based on the prior price of the 1099 adjusted for inflation, as you indicated. It is a 9.5% increase. And so at some point, you do have to make a determination about what is and what isn't reasonable. I don't think that it's strictly a percentage number or a dollar figure number. It would be on a case-by-case consideration. Staff looked at the overall filing in this case and the overall application and considered that to be a reasonable increase. But I don't think that there's any set barrier or set qualifier that staff determined that if it exceeds this specific percentage or this dollar amount, that it would become unreasonable. I think that, again, we look at that on a case-by-case basis. Additionally, I would indicate that staff presented this information as somewhat of a supplement to what was provided by El Paso Electric and asked for additional information from El Paso Electric to verify the reasonableness of that price. I believe that information was provided in rebuttal testimony by EPE witness Wayne Oliver, and that additional information would confirm staff's understanding and staff's conclusions in this paragraph that you have identified.
Okay, so at what point would the price difference in your mind or in your methodology that you applied here become unreasonable?
Your Honor, as I indicated, I don't think that it's a strict dollar amount or percentage amount. I think that it was just a judgment that staff made that, given the circumstances of the relative prices of the prior project and looking at what we've seen based on information provided by the company in its application, as well as additional information looking around at the context of other filings that come before this commission and other batteries, other storage options that have been proposed by companies in other jurisdictions, it was staff's judgment that that was a reasonable amount. It is not a pure percentage or dollar amount that staff was considering.
Thank you. My next question also deals with reasonableness, but this time with respect to your testimony regarding the increase in the rate rider amount. You provided in your testimony also a conclusion that the increase in the rate rider proposed by El Paso Electric would be reasonable. Is that correct?
Yes, sir. May I ask if you have a particular page or line number that you might direct me to so that I can be sure to follow the
Yes, I am.
direct my attention to?
Just give me 1 second. It is page 40. I believe it starts on page 40
Yes, sir.
regarding unreasonable price impacts. And you write, quote, while this data provides only a snapshot in time, it illustrates that even though renewable energy costs for EPE's New Mexico customers are increasing, the overall impact of increasing renewable energy costs has not necessarily imposed an unreasonable bill impact to New Mexico customers. For example, a customer consuming 1,000 kilowatts, et cetera, et cetera. So in this section of your testimony, you describe the price increases of the proposed rate rider to be reasonable. And I believe it was also, you discussed the precise dollar amount, like what it would cost in the summer and what it would cost in the winter for an average customer. Is that correct?
Yes, I believe in this section of my testimony and the section immediately following, I am comparing El Paso Electric's cost increases to the RPS rider in consideration of relative increases to the rider historically, looking back at 24 RPS rider and showing the cost increase relative to that. And I also compare the total customer bills at the conclusion of the 20-00104 rate case to the total customer bills if the RPS rider as proposed by EP in this case were to be implemented. And my conclusions of that information, I also do provide information based on prior commission interests regarding the displacement of traditional generation resources with renewable energy resources. So I cover a lot of ground in a couple of pages here, I believe. And what I'm trying to really illustrate is that though the relative increase year over year, when we look at it, and I point to this at page 37, at beginning at lines 1 through 4, discussing that the relative increase to the summer and winter bills are only a matter of 3.96 to 5.12%. And take it on their own, that's not a significant increase. Again, when we look at percentage wise, or if we try to look at the dollar amounts for the customer that's being there. But there's somewhat of a compounding effect whenever we look at those small increases over time. And so to determine the relative impact on a customer of that compounding effect, what I did was look back at a prior rate case conclusion, 20-00104, and I showed that, while there is this compounding effect of renewable energy increases, price increases for customers, the overall total impact customer bills compared to the time after the conclusion of that case is not dramatically, it is not too high in staff's opinion. And the way that I looked at that was comparing the prior bills at that point to what the bill would be under this case. And actually the amount that the customer consuming 1,000 kilowatt hours would pay has gone down. And I illustrated as well in that discussion that, this is only a snapshot in time. A lot of that is likely related to the cost of fuel for the other resources. But it does show that while we are seeing increasing costs as a result of increasing incorporation of renewable energy assets into the company's portfolio, that the overall impact to customers through time, staff believes is not unreasonable.
Yes, thank you. So just so I understand clearly, the baseline of your reasonableness determination is the prior energy costs or the bills or the prior rider amounts. Is that correct? You're looking at the difference between what was and what's proposed and saying that change, that delta is not so great. It's just a few percentage points, therefore it's reasonable. Is that the logic?
I think that I've tried to come at it from a few different points here, including what you've described just now. but I don't think that the reasonableness determination was set on one component alone. I've tried to demonstrate for a few reasons why staff believes that the
Sure.
relative increase,
I'm sorry, why staff believes.
that the relative increase is reasonable.
Mr. Dunn, did you consider cost of living or income or any kind of per capita income or other economic data of the customers in El Paso vis-a-vis the price increases?
No, sir, that was not a specific consideration that was taken in my analysis in this particular case. I will note that staff generally does recognize that New Mexico is a state that has a large portion of customers, of ratepayers that are low income. And so that is always an ever-present consideration in staff's mind when we do evaluate a case and the relative impacts of any increases to bills for customers. Thank
you. I don't have any other questions, Mr. Dunn. I really, truly, we very much appreciate the time and effort you put into your testimony and for taking the time to be with us today. I really can't thank you enough. Mr. Bagacco, do you have any redirect for your witness?
Just very briefly, if you would. Mr. Dunn, just dovetailing on that and expounding on the discussion regarding your reasonableness determination, your analysis that supports that is also informed by the mandate and the policy purposes of the Renewable Energy Act, is it not?
Yes, sir.
And the benefits that can be realized pursuant to that policy as they would reflect on or devolve to the public interest. Is that another consideration informing your position regarding the reasonableness of the presentation in this case?
Yes.
All right. Well, that's it, Mr. Hearing Examiner. Mr. Dunn, thank you for your indulgence. I would pass the witness and maybe rest staff's case if you'll allow me.
Yes, I think so. I don't think we have any other witnesses for staff. And again, Mr. Dunn, thank you so much for your time and effort in preparing your testimony and for being with us today. And you may be excused.
Thank you, sir. I appreciate it. I hope everyone has a wonderful day.
Thank you. Take care. Bye. Well, it looks like we've come to the conclusion of our witnesses. I believe El Paso Electric has presented and provided their witnesses for cross-examination, as has staff. Are there any other matters to discuss before we start to wrap up our hearing? No? Okay. Well, let me say thank you to everybody, and please communicate this to your witnesses as well. For, I think, a very informative, valuable, and meaningful hearing. I thought it was efficient, and I tried to really make sure that everyone's time was valued and that everyone's effort was valued. So I just want to express our gratitude and thanks on behalf of the Commission. I think our next step is just to talk briefly about post-hearing briefs. And yes, we will also discuss the transcript in a minute. But for the post-hearing briefs, I don't want to go into the specific issues that we want addressed. I think it's been a long day for all of us, and we can communicate that to the parties of what issues we would like more legal and maybe factual, but probably more legal analysis on, if any. And we are also operating, just for everybody's awareness, under a bit of a new expedited timeline for the Commission because of the Commissioner's desire to have their recommended decision quite a bit sooner than normal. Now, I don't think that will shorten the briefing period, but we will communicate that with you as well. Now, also, I just want to briefly discuss if anybody has a need for an expedited transcript. We can also deal with that as needed. But I don't know if that will be the case. I think we had not even a full day's hearing today, so I don't expect Ms. Gonzalez to take too much time in her normal course of preparation. So are there any other thoughts or concerns? Ms. Olson, you have a curiosity?
Oh, I was just gonna say on the expedited transcript, I don't think there's any need for that in this case, but I would, this is probably obvious, but ask for the briefs to be due after the transcript is available so that we have
Absolutely.
the benefit of the testimony.
Yes, absolutely, of course. Any other thoughts, curiosities from the parties, considerations for the commission or the hearing examiners? No, hearing none. Again, thank you so much for everybody's time, and really enjoyed our discussion today, and we'll be in touch shortly. Thank you so much.
Thank you so much.
Thank you.
Good day.
Thanks, everybody. Take care.
One question, Miss Olson,
Yes.
are you going to upload the transcript? I forget which one had a correction that wasn't done. Was it yours?
Yeah, I'm not sure. I'm happy to like file it or provide a complete replacement, or I can just give you the page to substitute. What would be easiest?
From my perspective, just a brand new transcript so that I'm not, because I don't really print them or do anything with them. I guess we could replace the page. I guess my office can do that. I don't know what my office can do.
It's no problem either way. I'll just provide a wholly replacement. The only, I guess, limitation is I think the Dropbox is not available for uploading anymore. Am I right on that?
Okay.
So if the hearing examiners are able to allow access, or I could be completely wrong.
What was the question again, Ms. Olson?
If the Dropbox is the upload link.
Yes, I think that the first email link that or the first link that I sent in the email, the exchange, yes, I believe it's still active.
Okay, then I'll just upload it and I'll title it Replacement Exhibit 5.
Okay, or corrected, whatever you usually do. Yeah. Okay.
We can do that right now.
Okay, then I'll get it right now. I mean, later.
Or in a few minutes.
Yeah, exactly. I know it takes time. All right, that's all.
Thanks, everybody. Be safe.
Thank you.
Take care.
Bye-bye.
Thanks again. Bye-bye.